what we can see, but you can't behind you.
Well, I can see, actually.
Oh, you can see. Oh, so you've got
yes.
it, yeah.
Yeah. Thank you. Can I just check, actually, does anyone in the room have any objections or require any further information in this respect about being recorded? I mean, the cameras are actually seem to be focused towards the front and the main parties and the advocates and so forth. Does anyone else intend to film or record the event? No. And is there anyone here from the press? Yes, sir. Could you just confirm your name and who you're representing? That would be helpful. Use your microphone, that would be great.
Yes, Nigel Slater, local democracy reporter with Derbyshire Live and the BBC.
Thank you. Nigel Slater, you say?
Yes.
Okay, so interested parties, I'll just come to the couple that I have already registered to speak to the inquiry. Councillor Jonathan Smale, thank you. And obviously you're talking in the capacity, or addressing the inquiry in this capacity as a local councillor. I noted you object to the proposed development. Can I assume you'll be happy to answer questions if required on your evidence? Yeah. Yeah, okay. And you'll be available this morning after opening statements? Yeah. Do you have a script that you're planning to read from to address? Yes. Would it be possible to, I don't know if you've got copies that could be potentially shared? Okay. And I think there's, Isabel provides a minister if you need to help in terms of photocopying. That would be useful so it can be circulated to the main parties and myself. And Kevin Palmer? Sir. Thank you. And you're speaking as a local resident, I presume? Indeed. Yes. Thank you. Say again, sorry? I said, on behalf of the local resident. Okay, but no formalised group as such, just... No. Yeah, okay. And I assume you're also happy to answer questions on anything that you say? I'm sorry, sir, I'm not very rude. I can't hear you. Okay. I assume you'll be happy to answer questions on your evidence if required? After you've spoken to the inquiry? Yeah. Yes. Okay. Yeah. And again, are you intending to read from a script? I've got 4 pages here, sir. It would again be useful if you just, for avoidance of doubt, to have photocopies to circulate to myself as well. I know Isabel's available to help with that if necessary. Is there anyone else who'd like to say something at the inquiry? Yes, sir.
Yeah, my name's Councillor John Wright. I'm both a resident and the councillor for the adjoining ward to the green wedge that's the subject of this matter. Thank you.
Thank you. And just to run through the same questions, I assume you're happy to answer questions if required?
I am, and I've got a speech and I'm happy to share it.
That would be great, yeah. Again, photocopies for circulation would be helpful. Anyone else intending to address the inquiry today? Okay, thank you. Please do note the position of the witness table, it's here to my left. This is where I'll hear from the various witnesses at the relevant time. Unless requested otherwise, I anticipate that advocates shall sit at all times rather than stand during the event. And can I ask all attendees mute your microphones to guard against background noise when not actively participating, but obviously when you do speak, please ensure you turn your microphone back on. I've been provided with a copy of the Council's letter of notification of the appeal, confirming the date, time and location of the inquiry, and the list of those who the notification was sent. I've also received confirmation that site notices have been displayed and a press advertisement has been published confirming the details of the event. I have copies of representations made in response to the original planning application consultation and notifications made at appeal stage, and I'll take these into account in reaching my decision. For the benefit of anyone not aware, I held a case management conference via Microsoft Teams on the 6th of February with representatives of the appellant and the council in attendance as the main parties in this appeal. The CMC was held purely to discuss the procedure for the inquiry, so the merits of the appeal were not discussed. Such matters as the identification of main issues, how the evidence is to be dealt with, and a preliminary running order for the event were discussed. 2 amended plans and 1 additional plan have been submitted with the appeal. The amended plans being an amended access plan and an amended illustrative master plan, and the additional plan being a landscape buffer plan. These were discussed at the CMC and consulted upon at appeal stage in the interests of full transparency. Perhaps for the clarity and for the benefit of interested parties attending here today, could the appellant please briefly summarise the differences when the amended plans are compared to the original plans now superseded, and explain the rationale behind the amendments and the additional plan that have been produced?
Yeah, it's a really simple point, which was we produced a master plan and the highway engineers produced plans which were not entirely consistent with that master plan. So we've simply ensured that there is consistency between the two, and the access was relocated to make sure that it's consistent with the master plan. It's the same access arrangements, it's just a slightly different location. But important to consult so people know.
Thank you. And in terms of the landscape buffer plan as well, just briefly summarise the rationale.
Yeah, we have looked to strengthen the landscape buffer because of the green wedge location, and hence you see a revised proposal with a stronger buffer.
Okay. And could the council confirm, well, I think it has already done so in the CMC, it has no issue with the appeal being considered on the basis of these amended and additional plan?
That's correct, sir.
Thank you. Okay. And I should say, if any interested party have any specific comments to raise with respect to the amended or additional plans, these should be raised in the following session after we have heard opening statements. So just to confirm the plans before me for determination, so obviously got those three that we've discussed, which I think are core documents 8.07, 08 and 09. Just with the illustrative master plan, can I just confirm, I think the original version was determined by the council as insofar as the means of access only, with obviously other elements of the plan being for information at outline stages. Is that the party's consideration of the same position as we're in now? Yeah. Okay. And just to confirm, the site location plan and proposed footway link details plans, core documents 1.17 and 1.21 are also for formal determination, is that correct? Yeah. Can the council confirm as well?
Yes, the location plan would certainly be the one that defines the red line. The footway plan, as far as there's a requirement to have links to it, may need to be the subject of condition, but they're likely approved plans or through condition. Okay.
But at this moment in time, it's a plan for me to consider. So, yeah. And just a couple of clarifications on other plans, which I think were considered for information purposes at application stage, and just their status, just confirmation at this moment. And that there's an illustrative tree and hedgerow retention plan, which I don't think has got a core document reference number, but the end of its reference is 12 revision A. Can I assume that's still relevant for information purposes, notwithstanding the amended plans that have come in?
Yeah, I mean, it has the badge illustrative because it's not for your determinations, as you've just alluded to, simply there to assist in how it might be achieved.
Okay. It's still relevant at this point, it's not been superseded?
Yeah, not superseded, no, but nor ultimately on an outline, something that you can rely upon as a basis for making a judgment, simply to assist in seeing how that could be achieved.
Okay. And does that still apply to the vehicle tracking plan, noting that the access is amended in terms of its position? Is that still a relevant plan?
The council needed that to be satisfied that the necessary vehicle movements could be achieved, and it having done so, I don't think it has any other status than us having satisfied them of that.
Okay. And just for formal confirmation, in terms of the illustrative landscape master plan, which is core document 1.18, I assume that has been formally superseded now in terms of the landscape. Okay. Thank you. So I've received proofs of evidence from Councillor Holmes from the council side, and from Miss Ellinsfield, Mr. Lees and Mr. Stacey from the appellant's side. I've read these proofs, and so I would expect them to be taken largely as read. It's my understanding that all parties have had access to all of the proofs, but please do make me aware now if not. For the avoidance of doubt, these are available to view via the council's website.
Excuse me, I'm just checking that you've received communication on behalf of Jonathan Davis, the MP.
I have.
Who was hoping to be here
I will come on to that and confirm that in due course. Yeah. Yeah, it has come in, yeah, and I'll come to that in just a minute. Interested parties should be aware that all core documents and inquiry documents are being stored via a dedicated web page which is accessible as a link via the Development Control section of the Council's website. Thank you to all those involved with setting this up. This is to be updated on a regular basis to take account of any inquiry documents handed up to me during the event. Regarding the appeal's main issues, it's apparent that the latest appeal evidence, which includes a statement of common ground specific to housing, that agreement has been reached between the appellant and the council with respect to the council's acknowledged housing and affordable housing supply shortfalls. To my mind, it would therefore appear that a single main issue should be the principal focus of this inquiry, which is the effect of the proposal upon the function of the Spondon Green Wedge. Has anyone got any comments upon the scope and wording of the main issue? I'll come to the appellant first, please. Thank you. I shall follow the procedure in the 2000 inquiry procedure rules. As such, when I've concluded my opening remarks, I shall invite the appellant and the council to each make a brief opening statement. This will help everyone to understand the main arguments. In accordance with the draft inquiry timetable that has been circulated, and I think there's a couple of copies dotted around at the back there for anyone who's not had sight of it, I shall then hear from interested parties. The formal presentation of evidence and cross-examination shall then follow. This shall commence with the council's witnesses' evidence-in-chief, followed by cross-examination by the appellant as opposing party, and then re-examination. The parties shall note from the draft timetable that I have provisionally suggested evidence-in-chief for the session after lunch, and then cross-examination and re-examination following the afternoon recess. In reality, it could be that cross-examination straddles the afternoon break or strays into the second day, which is largely dependent upon how this morning pans out. But are the parties content to proceed with flexibility on this basis, noting that it could be the case that Mr. Councillor Holmes is left in Purdah overnight?
Yes, so we'll want to conduct the inquiry to make best use of the time. Councillor Holmes is also prepared to give his evidence in chief before lunch if there is time to do so.
Okay. Yeah.
Yeah, all fine, thank you.
Then the appellant's witnesses shall be called on the same basis, although with cross-examination instead by the council's advocate. Firstly, Ms. Ellensfield with respect to landscape visual and green wedge matters, and then Mr. Lees with respect to planning policy and overall planning balance matters. I shall indicate during proceeding when interested parties who have indicated that they wish to speak and whom oppose the proposal shall have the opportunity to ask questions. I may also ask questions myself at any stage during the proceedings, most likely following cross-examination. When the formal evidence has been dealt with, I shall lead a roundtable discussion on conditions and the planning obligation. It may be possible that this could be fitted in at the end of tomorrow afternoon if timings were to allow, but for the purposes of the draft timetable, I've suggested Thursday morning. A session of this nature is standard procedure and does not indicate that I've made up my mind on the case and does not weaken the council's position in relation to the proposal. A site visit, which I shall come on to in a bit more detail in a second, is also programmed, which could occur on Thursday prior to closing submissions or an alternative point in proceedings if timings were to allow and the parties were in agreement. And then we shall finish with the closing submission of the parties, which should be as concise as possible, bearing in mind that my directions following the CMC indicated they should ideally be limited to 30 minutes. I plan to have a lunch break of around an hour each day, with short breaks in the morning and afternoon, so there should be 4 sessions each day, although there is flexibility to some degree depending on when natural breaks in proceedings materialise. Are there any thoughts on the draft timetable that has been circulated in terms of its realisticness and the running order put forward?
No, I don't think there's any risk of us overrunning the 3 days. So with a fair wind, we won't need the 4th day that's later on in the month.
Yeah, okay. I plan to commence each day at 10 a.m. and aim to finish around 5 p.m. each day. Indeed, I'm informed that today we need to vacate the room by 5 p.m. in advance of a committee meeting later. Could the council confirm if there are any similar constraints for days later in the week in terms of having to vacate the room by a particular time? Just today. Okay. And could I ask that parties remove their belongings and documents, particularly tonight in advance of another meeting that's happening in here tonight? And I think there's no guarantees that the room will be locked, so yeah, you should take your belongings with you at the end of each sitting day. The 10 a.m. start time can be reviewed if necessary. For example, if a 9:30 start could be beneficial for the purposes of keeping to timetable. I will confirm the start time of the following day at the end of each sitting day, but as a starting point it should be 10 a.m. I shall keep the timetable and all timings contained within it under review as we progress. If the applicants think any additional adjournment is necessary at any stage, please do let me know. So a list of conditions has been provided, which is core document 8.14, which has been worked upon by the parties that I envisage being used as the basis of our conditions discussion later. I presume the parties are happy to leave it at that at this point regarding conditions. We'll come to them later. Yeah. In terms of planning obligations, section 106, I've seen a revised final draft that came through on the 11th, Friday the 11th of April. Are there any further updates on its latest progression in terms of the timescale for a signed version? Not at this point.
Yeah, it's all agreed. So what we don't want to do is sign it and date it before you passed your comments if you've got any observations, but it's all ready to go.
I know we'll come on to discuss maybe some of the points in more detail when we get to the round table, but my first review of the latest version, I noticed in Schedule 2, or the version I've seen, there were 2 Part 1s and missing Parts 2 and 3. So it's sort of replicated Part 1s, I think one with a different mechanism for the healthcare contribution. But,
thank you very much for reading that with that degree of care, and obviously we'll get that straight back to the solicitors when they're busy chopping and changing and multiple track changes. They sometimes miss these things, and it's difficult to read your own work sometimes, isn't it, and see where your mistakes are. So that's very helpful, and we'll obviously look into that today.
Okay.
And just so that people know, what we've been talking about is at core document 8.15 through the website.
Thank you. Yeah. And that's the latest version, yeah. So in terms of the site visit, I did conduct an initial visit to the site on my own yesterday in order to familiarise myself with it and its surroundings. However, as already confirmed, I will be making an accompanied site visit at some stage during the event. It should be solely for me to see the site and its surroundings, so whilst physical features can be pointed out, there should be no discussion of merit whilst on site. I should need to be accompanied by representatives of each of the main parties, with interested parties also welcome to attend should they desire. An itinerary for the site visit has, I understand, been discussed and agreed between the main parties, and there is, again, a couple of copies of that itinerary dotted around at the back of the room for anyone who's not seen it, which could be amended to or added to as evidence emerges during the inquiry. The Council has agreed to provide a point of contact for any interested parties wishing to attend the site visit who may not be at the inquiry after today. And that point of contact is Isabel, who's sitting over there by the door out. So this will enable the timing and meeting point details to be shared once confirmed. So anyone interested in attending, please do provide your details to Isabel. I'm not inviting any applications for costs, but if anyone intends to make an application for award, this should be done here before the close of the inquiry. At the CMC, the respective parties indicated that no costs applications were anticipated. Is that still the case? Okay. From the council's perspective.
Not from the City Council. It would be useful to know whether there will be an application before Councillor Holmes gives evidence, because it always helps to call the witness against a known background on the cost application position.
Yeah, the time for notifying costs is at the end of the inquiry, and I'm not going to do it just before the councillor gives evidence. I'm not sure the two are coincidental, actually. It needs to be done before the end of the inquiry.
I think it's probably best practice to be done as early as possible. I think the guidance suggests before the inquiry opens.
It does indeed, but that's not what the rules say. The rules say before the end of the inquiry. So, and there's a variety of reasons why you might not follow the best practice guidance. I'd like to hear what the councillor has to say first. His evidence is relevant to that.
Okay. Any final thoughts in response to that, Mr. Richards?
No, very helpful, thank you.
In addition, I have a power to initiate an award of costs myself, whether or not any applications have been made by the parties, and if I were to do this, it would follow a written process with the relevant party after the appeal decision is issued. In terms of late evidence, I saw an additional proposed core document came in yesterday, which appears to be proposals map for the Spondon local plan dating back to 1982. Can I just check that that has been or was discussed between the main parties and there's agreement for it to be added and contained within the core documents list?
I'm not sure. It was initiated by the council. I'm not sure whether it was discussed with the appellant. No. I think it's to show you how far back green wedges have their parentage in policy terms. But perhaps we can talk about that.
Yeah, but I'm going to just check, has the appellant seen the addition?
I saw the plan, yes.
Yeah. Are you content for it to be?
Yeah, I did. It causes no difficulty, yeah, that's fine.
Okay, it's okay. I think it's got core document reference 9.33. Was that might be the suggested reference. I'll just note it down. Oh, it is on there, it's 9.33, yeah. Okay. And Mr. Palmer alluded to a letter from MP Jonathan Davies, which did come in recently and was accepted yesterday as evidence that's before the inquiry. It's been circulated to the main parties and it has got a document reference number. It's available to view via the council's webpage showing the core documents. And we're content with the reference 12.01 being an inquiry document reference. Either party. You okay with that?
Yes.
Okay. Thank you. All of the documents and evidence should already have been provided. However, if anyone intends to submit anything further, can you please tell me now? Thank you. I should also note that only exceptionally shall material received after the close of the inquiry be accepted and taken into account. That concludes my opening remarks. Are there any queries about the procedure or other matters before we start? Okay. In that case, can I please ask Mr. Young to make a short opening statement?
So we've reduced it to pricing, so
Yes, yeah. Thank you.
And so we've allocated the core document 12 series as inquiry documents. We've already got the letter from Jonathan Davies MP as CD 12.01.
Yeah.
So this would logically be 12.02.
12.02, yeah. I'll refer to it myself as an inquiry document rather than a core document, but yeah, it's fine for it to be listed as that on the council's website. Yeah, 12.02.
Okay, the appellant's opening statement. This appeal concerns an outline planning application for residential development, including access arrangement for up to 90 dwellings, which was refused by the Planning Committee at Derby City Council, the local planning authority, despite a recommendation for approval by the planning officer. This is a highly unusual appeal in that there is more common ground than uncommon ground between the parties. In terms of housing need, the local planning authority accepts that its position is appalling. It has a 3.85 year supply, a significant shortcoming against a 5-year housing land supply requirement, such that the local planning authority accepts that very significant weight should be applied in favour of applications that can contribute to increase the supply. 2,000 plus dwellings in the local planning authority's housing need are unaccounted for in its current Derby City local plan core strategy from 2017, based on new housing requirement figures. There is a very significant need for affordable housing within the local planning authority area, demonstrated by the fact that on the 31st of March of last year, there were over 8,000 households on the housing register within the local planning authority in desperate need of a home, which has increased drastically since at least March 2022. In terms of landscape, the local planning authority accepts, amongst other things, that the appeal site is not a valued landscape for the purpose of paragraph 180A of the NPPF, nor does it lie within any formal designations of relevance to landscape and visual matters. The appeal site is well screened and enclosed from long-range views by existing built form topography and landscape features. The most visible part of the appeal site from the wider landscape is planned to be the open space, with landscape planting and retention of trees and hedgerows, and the proposal would not be unduly prominent in views from the Green Wedge and the wider townscape. In terms of the benefits of the scheme, the local planning authority accepts that, amongst other things, the following are benefits: the provision of a large number of new homes in a sustainable location forming a part of the built area of Spondon, the provision of affordable housing where there is a very significant need for such housing, on-site provision of biodiversity net gain, the provision of a new accessible open space through landscape planting and habitat creation, and the temporary economic benefits from construction through job creation and economic investment in infrastructure, although you, sir, will be aware that the appellant will assert the substantial long-term economic benefits that arise from the operation of a large housing scheme as well. Notwithstanding all of the above, the local planning authority object to this proposal on the basis of a single reason for refusal, that the appeal site is situated within a green wedge and therefore is in conflict with policy CP18 of the core strategy. The LPA's case is that this conflict with policy CP18, which was adopted some 8 years ago, and on an understanding that there is likely to be a need to release some greenfield land, potentially even within the allocated green wedges for housing, is such an adverse impact that it is single-handedly, significantly and demonstrably outweighs all the other benefits of the proposal. Putting to one side the LPA's own untenable position, the local planning authority's case is the appellant's case is threefold. First, CP18 is out of date due to the local planning authority's poor housing land supply position and its conflict with the NPPF. Therefore, any conflict with this policy should be afforded limited weight at best. Second, the proposal would not adversely impact the strategic function of the Spondon-Chaddeston Green Wedge, nor would it lead to an unacceptable narrowing of this green wedge. And third, overall, the benefits of the scheme significantly and demonstrably outweigh any adverse impacts on the basis of paragraph 11D of the NPPF. Market and affordable housing need, the appellant's evidence will show, and that too in the absence of any evidence to the contrary from the local planning authority, that there is a significant and unaddressed shortfall of provision in housing by the local planning authority, which is demonstrated in the 3.85 years supply, the 83% housing delivery test score, and the lack of any signs, let alone any actual progress of a new local plan to address the severe housing needs faced by the LPA. With regards to affordable housing need, the appellant's evidence demonstrates that there has been a chronic undersupply of affordable housing over the past decade, a shortfall of over 6,000 affordable dwellings over the 11-year period, and an average annual shortfall of 598 affordable dwellings since the adoption of the 2013 SHMA, on which the core strategy was designed. Furthermore, the evidence shows that it will be entirely fanciful to think that this affordable housing need may be met were the LPA to continue on its current trajectory, taking into account its policies and loss of existing stock from the right to buy scheme. This is demonstrated by the waiting list for a home within the LPA, which are woeful, ranging from 14 to 27 months, and with 395 households in temporary accommodation on the 31st of March 2024, a 103% increase from the 31st of March 2023, and 70% of those households being households with children. Although these families and households may not be present at this inquiry, the benefit of this group must be acknowledged in full for which it is, and not just mentioned in passing as one of many other benefits. Policy CP18. The appellant's evidence to this inquiry will demonstrate that policy CP18 must be deemed to be out of date, not only because of the poor housing land supply position, but also because of this policy's glaring conflict with the MPPF itself. Policy CP18 does not allow for any balancing exercise to be undertaken to determine whether a proposal should be allowed on the green wedge, and it simply ignores new housing schemes as being a possible proposal on a green wedge in any circumstances. This approach is clearly too protectionist and in conflict with the MPPF. Furthermore, the appellant's evidence will show that policy CP18 was adopted on the basis of a green wedge review undertaken in 2012, some 13 years ago, and therefore is based on evidence from a snapshot in time without taking into account the material change in circumstances that have occurred since. Policy CP18 and the designation of green wedges were intended to be kept under review, as is clear from the wording of the policy itself, via Part 2 of the core strategy. However, no Part 2 of the core strategy ever came forth in the past 8 years, and it does not look to be coming forth either. In addition, the evidence will demonstrate that policy CP18 was adopted on the basis of a reduced housing need calculation by the LPA, relying on 2 neighbouring authorities to make up for the shortfall, one of which has been able to provide no housing whatsoever to meet the LPA's local housing needs. The LPA seeks to rely on an appeal decision from 2016 to show that policy CP18 remains an up-to-date and relevant policy. However, the error in this reliance is evident on its face, given this was a decision from 2016, some 9 years ago. The appellant's evidence will further demonstrate that in addition to the material change in both national policy and local need, the specific locational differences between the current appeal site and the site which formed part of the 2016 appeal decision render the 2016 appeal decision incomparable to this appeal. From a landscape perspective, the appellant's evidence will demonstrate that notwithstanding a conflict with the wording of policy CP18, the actual harm to the function and objective of policy CP18 and the Spondon-Chaddeston green wedge is limited. The only detailed landscape assessment that considers the harm are those carried out by the appellant's expert and the LPA's own planning officer, both of which conclude that the function and character of the green wedge will be retained if the proposals were to go ahead. Overall planning balance. The appellant's evidence will set out the numerous benefits of the proposal, including the social benefits from the provision of market and affordable dwellings amidst a national and local housing crisis, the benefits associated with the provision of amenity green space and major open space, along with new and enhanced pedestrian and cycle routes, which will benefit the wider community. The myriad of economic benefits at both the construction and operation stages of the proposal, such as from household expenditure and the creation of employment opportunities during the construction phase. The environmental benefits in the form of enhanced cycling and walking infrastructure, prioritising sustainable transport modes, and the site itself being in a sustainable location with good access to local amenities. Not to mention the proposed on-site biodiversity net gain to be provided with a biodiversity net gain equaling 11.3% for habitats, 32.25% for hedgerows, and 78.09% for watercourses. Furthermore, given that it is accepted that this case engages the tilted balance, the presumption is that the planning permission should be granted unless the adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies of the MPPF as a whole, having regard to the policies in footnote 7 of the MPPF. The appellant's evidence will show that the proposal is compliant with all relevant footnote 7 policies, namely relating to affordable housing, the sustainable location of the proposal, the need to make effective use of land, and good design. Therefore, considering the proposal's compliance with footnote 7 policies and the MPPF as a whole, and taking into account the numerous benefits arising from the proposal, the appellant will argue that the adverse impacts in the form of conflict with a single and out-of-date local policy comes nowhere near outweighing the benefits of the scheme, and certainly not to any significant degree. And for all the reasons, you'll be invited to being asked to grant permission for this proposal.
Thank you very much. And yes, can I hear from Mr. Richards, please?
Did everybody accept it?
Yes, I did notice. Thank you. So I'll sign that reference 12.03. It's in your own time, thank you.
Thank you, sir. And you'll see at the start I've indicated our appearances for you. So the adopted Derby City Local Plan covers the period 2011 to 2028. Adopted in 2017, it is predicated on delivering 11,000 dwellings over the plan period out of an assessed need of 16,388. The remainder being exported elsewhere in the housing market area. The need was therefore for an average of 964 dwellings a year over the plan period, although the plan's requirement was for 647. During the time of the 35% uplift, it rose to 1,244. It's now at 906 dwellings a year, based on the standard method following its update in December last year. Derby was constrained from meeting its full need within its boundaries, in part because the city has already spilled over into neighbouring administrative areas, but also because it has Greenbelt to the north and east. More pertinent for this appeal, Derby also enjoys fingers of open, largely green wedges of land penetrating into the heart of the city and separating the city's individual neighbourhoods. Of course, the vision of the adopted local plan includes its residents having a home to live in, but it also includes providing an attractive living environment which, in the outer suburbs of the city, includes the 13 green wedges, which in part define the identity of communities and prevent the coalescence of one into another. Green wedges do not have the permanence of green belts. The extent of the green wedge is examined during plan making, but they do define the spatial character of the city in ways the green belt does not. In examining the adopted local plan core strategy, the inspector found that there was not a case for releasing Greenbelt within the city boundaries, but noted that the Green Wedge review had identified around 2,000 houses on land previously Green Wedge, and that further non-strategic releases would be considered in the Part 2 local plan. The Green Wedge designation is not a recent construct. In planning policy terms in Derby, it dates from 1989. But its roots go back even earlier, and it has continued in all plans since. It recognises a long-standing principle that as the city has expanded outwards, even as it swallowed up small settlements and villages, wedges of land have been deliberately left open and undeveloped. The appeal site is in one of these green wedges that separates Spondon in the east from Chadderton in the west, and it contributes to the character and sense of place of this part of the city. It contains a school and the playing fields of another. The land uses in this green wedge, as in green wedges generally, are various, but all contribute to the openness and separation function of it. Agriculture and horticulture, playing fields, nature reserve, public open space. The finger of housing development along West Road predates the designation and is technically outside the green wedge.
Other non-school buildings generally relate to agriculture. Core Strategy Policy CP18 is the Green Wedge policy. Its predecessor policy, E2 in the previous plan, is discussed in the 2012 Green Wedge Review at page 11. They're very similar. The policy approach is to establish a general presumption against most forms of built development in order to maintain the open and undeveloped character of the Green Wedge. However, the 2012 Green Wedge Review appears to have been something of a watershed, recognising, as it did, modern challenges which include the need to significantly boost housing and providing the green infrastructure and modern sports pitch facilities demanded by modern living. That led to the release of land from the Green Wedge to accommodate around 2,000 dwellings. But we are approaching the end of the plan period, and Derby does not have a 5-year housing land supply. Once again, green fields will have to be built on in order to meet the needs of the city's growing population. The stakeholders in the city are wrestling with a dilemma. Should we build over the Green Wedge to put a brake on outwards expansion, including into the Greenbelt? Or should the city continue to expand outwards where it needs to, while respecting and maintaining green wedges, as has been done for many, many years? This is at the heart of the issue this inquiry will consider. The starting point for determining this appeal is agreed to be the development plan. The proposal to build up to 90 dwellings in the Green Wedge is plainly contrary to policy CP18 and the development plan as a whole. But the tilted balance in the NPPF paragraph 11 is engaged. In Councillor Holmes's view, the harm to the Green Wedge does significantly and demonstrably outweigh the undoubted benefits of delivering more market and affordable housing, together with the economic, biodiversity net gain and other benefits that come with this development. Thank you, sir.
Okay, thank you for those opening statements. Before we come to consider any sort of adjournment, I think we should start with interested parties. For Councillor Jonathan Smale, are you prepared to come to the witness table?
Yep, thank you very much. Good morning.
Oh, you have to come up to the witness table just at the top here.
Yeah, it's fine.
Has it got a microphone?
It has here.
Thank you very much.
And just to confirm, Mr. Councillor Smale, in terms of copies, are they being made of your...
I have just sent over to Isabel.
Okay, just so I know whether parties and myself need to make notes. If we know there's a hard copy, that's
Yes,
helpful.
there is absolutely a hard copy, yeah. Okay, good morning. And first I would like to thank the Inspector for allowing me to speak today as a local resident and a ward councillor for this area. I'm here to support Derby City Council's decision made on the 23rd of May 2024, and that's to refuse the planning permission for the proposed residential development of up to 90 dwellings on the land west of Royal Hill Road, Spondon. This decision reflects the will and well-being of our community, backed by solid local policy respecting the long-standing importance of the Spondon and Chaddesden Green Wedge. Let me explain why rejecting this application was the right choice for the people of Spondon. This Green Wedge is vital to what makes Spondon and Chaddesden distinct. As a resident, I see daily how this area of green space acts as a buffer, weaving in the countryside into our urban surroundings. It's not just an area of green space, it keeps our neighbourhoods separate, preserving their unique identities and preventing sprawl that could merge our communities. I draw your attention to which has already been discussed, to the 2016 Local Planning Inspector Report, which describes green wedges as open, green expanses penetrating Derby's suburbs, maintaining their character, offering recreation and enhancing quality of life. That report underpinned the dismissal of an appeal at Acorn Way in the nearby Green Wedge, because development would erode its openness. That decision still holds great weight today, and the importance of this green wedge remains as strong as ever. Building up to 90 homes on this 4.51 hectare site would significantly narrow this green wedge. It is a very real concern that this would push residential boundaries westward, increasing the likelihood of Spondon and Chaddesden blending together. The council's refusal rightly states that this development would reduce the countryside's reach into our city, conflicting with policy CP18. I've heard from 116 local objectors, including my fellow ward councillors, who cherish this space for its role in defining our community's character, a character we must protect. I do recognise the benefits put forward: new homes, including 30% affordable housing, biodiversity gains and economic activity. These matter, especially with Derby's housing supply at just 3.85 years as of January 2025. The tilted balance in the National Planning Policy Framework gives these benefits weight, and I respect that. But we cannot sacrifice a strategic asset like this green wedge for short-term gains. The Council's decision holds that the harm, loss of openness, erosion of community separation, and breach of policy CP18 significantly outweighs those benefits. This isn't about ignoring housing needs. It's about meeting them in the right places, guided by careful planning. Derby is a very compact city with tight boundaries. That means our green wedges play a critical role, allowing green spaces to thread through our urban fabric. When the council shaped its core strategy in 2017, it balanced housing growth by allocating some green wedge land for around 2,000 homes, but only after thorough assessment. This site, I do not believe, has been given thorough scrutiny, and certainly not for the residents of Spondon. The new local plan is the right mechanism to move forward and carefully consider Derby's growth, not this appeal. Allowing this development now, prior to the now imminent local plan process, would set a dangerous precedent for further erosion, undermining the policies that guide our city's future. As a resident, I walk these paths and see families enjoying this open land. As a councillor, I've listened to their fears of losing it. The 116 objections show how deeply this green wedge matters to us and the local community. Planning must reflect our community's values, and this development risks trading priceless green heritage for a temporary fix. I urge you to uphold the council's decision to protect Spondon and Chaddesden green wedges for future generations. And thank you for listening. Thank you.
Mr. Young, did you have any questions for the witness?
Thank you very much, sir. Yes. Councillor, good morning. Can I just check, first of all, you're a councillor on the City Council, is that right?
Correct.
I just want to have a look at what you've been doing in terms of dealing with housing need. As you've said, you've adopted a core strategy, which is the Part 1 plan. Is that right?
Correct.
And you were due to complement that with a Part 2 plan, which had site allocations in it and development management policies, yes?
Yeah.
And in the Part 1 plan, the bit that you adopted, you said, we will include any additional allocations which are required and further development management policies that are not addressed in the core strategy, and the Part 2 document will allocate smaller sites and provide more detailed policies and guidance on key topic areas and locations, and you indicated that that will be adopted by December 2017. Now, December 2017 is obviously over 7 years ago, isn't it?
Yeah.
Yep.
Yeah.
So what happened to the plan you said you would produce and adopt over 7 years ago?
I can't speak for that. That is an administration of that time to deal with. Back in 2017, I was elected as an for the administration of Derby City Council.
Okay, so how long have you been a councillor?
I've been elected since 2016, but I wasn't a member of the administration of that time. So obviously housing policy would have gone through the cabinet member of the time.
Yeah, but you are a councillor, you are responsible for this council. With authority comes responsibility, and your council, of which you are a member, has completely failed to deliver the plan that it told the planning inspector at the core strategy it was going to do, hasn't it? That's a fact.
Well, that's your belief, but I don't believe that will be...
Councillor, you're not listening to me. That's a fact, isn't it?
No, I did no.
No, so you're in denial of the fact that the council said to the inspector, we will adopt the smaller sites and allocations DPD and development management DPD by December 2017. You don't think that's what was said?
I wasn't here at that time. I wasn't at that hearing, so it's not from... I'm not going to put, have words put in my mouth to try and get your worldview. I'm not qualified to speak on that specific element.
You're not qualified to speak about the local plan?
No, because I wasn't involved in that local plan of that time and involved in that inquiry. I know what certain aspects have happened in that inquiry, but I think the way that you're addressing me, saying that it's a failure from an individual ward councillor who I represent...
No, councillor, forgive me. I'm saying it's a failure of this council, of which you are a councillor, and you have been a councillor since 2016. So it's a question of whether you can take responsibility for it. And if you can't, that's fine. We know where you stand. Do you take responsibility as a member of the council for the council's complete failure to do what it told the local plan inspector it would do? No, you don't. No, I don't. Just so I'm clear, which party do you belong to?
Conservative.
Right, and the Conservative Party generally has adopted a position where housing targets are advisory, hasn't it?
Yes.
Yeah, yes. And it doesn't think that a 5-year land supply is always necessary. It thinks that a 4-year or a 3-year supply would be appropriate, yes?
Yes.
Yeah. As a party, a very substantial part of your electorate is the people over 50 years of age, isn't it?
I think you're making swinging...
I'm just asking if you recognise that.
I completely disagree with that. I think anyone can vote Conservative, Labour, Reform or Lib Dems. I think you asking this question is a bit inappropriate.
Okay, let me stick with the planning, okay?
He's trying to stick to something that's clearly relevant to the case before.
Yeah. Sorry, national policy is affected by different governments, and Conservatives have signed up to advisory housing targets, that's policy. They've signed up to not having greenbelt reviews, various things. We now have a new government, and that government wants to see plans adopted, housing targets met, greenbelts reviewed. You're aware of that, yes?
Yeah.
No more excuses, no more delays, no more pathetic attempts to delay things. This government wants housing delivery, doesn't it?
That's their view. That's their manifesto pledge, yeah.
So you've stood up here today to talk about a planning application for housing. What is the timescale for your new local plan, please?
I believe it is to be set in 2028.
2028.
I believe the first set of conversations have already been had this year, and I believe that a cabinet paper is to be produced for the administration in November.
I'm really sorry, gentlemen, here's just sort of prompting and commenting along. It's not appropriate.
But I believe that in November a plan is to be coming forward to full council, which will then go through a statutory consultation process with the public, and then obviously it will go through its various stages for adoption for 2028.
Okay, so that's the plan, but obviously nobody can take the council seriously, can they? Because you said you'd produce a Part 2 plan by December 2017. 7 years later, you still haven't done it. So do you accept there'd be a credibility problem with anything this council says?
No, because I think planning is always constantly changing, and that councillors come and go as well. The fabric of this council has changed significantly in the last 10 years. So I think to pin it as a credibility issue on individual councils or councillors as a whole is incorrect. I think that with a new plan coming forward in 2028 would be the right approach in addressing our housing needs and redressing some of the balances and the issues that we face with housing.
Okay. Do you know if the council intends to address the large-scale housing requirement that the government has set it?
Yes, I'm fully aware it needs to do that, and I think that the local plan is the right policy framework to do that.
Yeah, absolutely, but of course we don't have one, so that's the difficulty. And in its absence, you of course recognise that speculative applications, windfall sites will come forward, won't they?
Yeah.
Yeah.
But,
and as far as the green wedge is concerned, you appreciate that that's one of the most important policies for determining the application, yes?
yes.
Yeah, and as a consequence of which, it's automatically out of date, isn't it?
No, I don't disagree with it being out of date. This is the local plan as it's set out now, and it's the CP18 pledge. CP18 is a policy that's still active now. We're clearly going to have a different opinion on whether it's out of date or not. But as far as I'm concerned, this council, this chamber, at the time when the local plan was adopted, is, in my view, still the correct policy to apply. Because
Councillor, it would be my fault.
Sorry,
Sorry.
don't interject when the councillor is making his response to you.
Sorry,
I don't think you finished.
no, I'll take it as a stop there.
Yeah, okay. So I thought you had to stop, but that's my fault. I apologise. So, Councillor, just so I'm clear, do you accept that the green wedge policy is out of date or not?
No,
No,
absolutely
okay,
not.
That's fine. We understand your position on that. What is the scale of your housing waiting list, the number of households who are waiting affordable housing on your housing register?
I can't.
The gentleman's just shaking his head, and I'd really be grateful if you just didn't get. It's not a public meeting.
Any sort of influence, please.
Just not moving or shaking your head or nodding or talking.
Don't influence anyone who's on the witness stand, please, if that's what the case is.
No.
Thank you.
I can't give you the specific number today, but I mean, you were putting your opening statement of the increased numbers, and obviously, I think there is well documented across Derby of the waiting list, and obviously that the people that are in homes or temporary accommodation, and that has been very well documented. I can't give you the actual detailed number.
Councillor, I read it out. I read it out this morning. I would have thought it was a number you recognised, but you don't know what it is, do you?
Not the current up-to-date one. You gave the one at the end of March, was it? Or was it January, did you state?
It's the March 2024. That's the latest figure. We haven't had the figure for this year. So just help me with this. That 8,000 people on your housing register, I mean, that is awful, isn't it?
Yeah, I think everyone agrees that we need more housing, and the waiting lists are really, really high. I just want to understand where you're coming from here. I think you're trying to badger me into a position here, into accepting that this housing is going to resolve all of the city needs, which I don't agree it will. I think we're talking about 90 homes on green wedge policy, and that is where my focus is as a local ward councillor for the local community representatives.
Okay, Councillor, let's unpack that, okay, and take our time this morning to get all of this right. So first of all, you're suggesting that I am saying this proposal for 90 houses would solve your waiting list. I haven't said that, and it couldn't, could it? Because it's only 90 houses. In line with policy, it's 30% affordable housing, and your waiting list is over 8,000. So how could I suggest that this proposal will solve your housing crisis?
It's just the way that you're putting your questions forward,
Okay.
and trying to make it quite intimidating.
Okay, do you accept that mathematically our proposal couldn't solve your housing waiting list problem?
Yes.
Yeah, obviously, okay. So the second point is I asked you whether that 8,000, more than 8,000 households on the housing register was awful, and you said we agree there's a housing problem, but that's not really answering my question. So can I go back to it? Do you recognise that to have over 8,000 of your own families and individuals on your housing waiting register is awful?
Yes.
Yeah, good. Okay. So what's happening is that the council is actually seeing less new affordable housing being delivered than it seeks to achieve. In other words, what I mean by that is after right to buy losses are being deducted, then what we're seeing is a net reduction in your affordable housing stock. Were you aware of that? That's what happened last year.
Yes.
Yeah. So you're now losing stock and you're making the problem worse by not having allocations to deal with that, aren't you?
Yeah.
Yeah. If you'd adopted an allocations plan in 2017, as you told the planning inspector, then it could have dealt with allocating sites, some of them on green field and green wedge sites that would have delivered housing, yes?
Yes.
And you could have made a meaningful attempt to reduce that figure of 8,000, yes?
Yes. Yeah.
We hear at inquiries like this from all the people who've already got a home, often built on a greenfield site in the 1960s and 70s. This inquiry is no different to the hundreds and hundreds that I've done. But we don't ever hear from the people who need that housing, and the inspector has said he doesn't want to hear a witness on that issue because it's agreed. So how do we get the voices of these people heard at inquiries like this, the 8,000 households who are in need of housing? How does their voice get heard?
Look, their voices do get heard. I think all local authorities recognise the strains that they need to put housing. I think we're going to be clearly clashing on this particular issue. But my view is that the housing needs to be done where, in our view, is in appropriate locations. So the 8,000 people that you refer to do get heard to. It's well documented that we do need more housing. But with our own city being in such a constraint, tight boundary, we are in danger of enveloping all of our green spaces in this city. Yeah. That is my own personal view. And I feel that we need to make a stand on particular green wedge locations. And this is one of them where I firmly believe. Now, I know we shouldn't talk about previous developments. We're firmly focused on this one. But Spondon has had so many green spaces, so many areas developed on in its historical history. And yet it's come with very bare minimum support. So I believe Spondon itself has done its fair share of development to support try and support the 8,000 people that we need to have in our homes. I mean, south of the Nottingham Road corridor, for example, you could probably count towards over 1,000 new properties that have been built in the last 15 years alone.
Yeah.
So to say that, you know, how do we get our voices heard and what we as a community and what we as a local council have done to try and support housing need, I firmly believe Spondon has done its very fair share.
Yeah. In terms of those sites that came forward, 1,000 houses, I think you said, south of the Nottingham Road, did that deliver affordable housing?
Most of them, yes. They've all come with either like a percentage, like 10, 20 or 30. Yeah. Yes, and some of them have been adopted by the HIMO, that is Derby Homes, which is Derby City Council.
I'll just come in at this point. Obviously, we're in the context where I've said I don't want to necessarily hear any more evidence about affordable housing. I'm confident that I understand the positions of the main parties, so I don't necessarily need to go into too much depth, necessarily helpful for me in this context.
Okay, well, if it's not helping you, then I'll stop on the affordable housing. We won't talk about that then. The position with the core strategy is, of course, it's based on a much lower housing figure than the government's new housing figure, isn't it?
Yes.
Yeah. So the core strategy has been delivering houses at the wrong rate since the standard method was introduced in 2018. Are you aware of that?
Yes.
Yeah. So what we get each year is more and more inadequate housing delivery, and as a consequence of which, Derby's not meeting and hasn't been meeting since 2018 the requirement the government sets, yes?
Yes.
Yeah. Now, if you had a local plan, you could obviously make your case to the local plan inspector and say, look, we are physically constrained and we've got areas we want to protect, and therefore we are not going to meet our requirement. But because you haven't got a local plan, that option isn't available to you, is it?
Sorry, can you repeat that question?
Yeah, by all means. If you'd adopted an up-to-date local plan, you could have made your case to the local planning inspector that you would you can't meet your housing need physically because the city's constrained, and there's areas that you want to protect, green wedge areas, and could have tried to persuade the inspector through that sort of democratic process and independent scrutiny. That would have been available to you if you'd gone down the process of an up-to-date local plan, yes?
Yes, but that new local plan is now starting to come forward, which...
I understand that, but you'll appreciate the inspector can't give that any weight because he hasn't seen it yet.
No.
And, okay, so the council really is the author of its own misfortune, isn't it? It could have advocated for an up-to-date plan with green wedges in and made the case to meet less than its identified housing need, but it's simply chosen not to do so.
If that's, I don't believe that's the case, because whilst there's been a clear intent to have part two, the original policy applies. So whilst we're going to have, again, clear and different views on what CP18 looks like and around what green wedges would look like in future, but that policy, to me, was democratically voted on at the time, which, again, was, a while ago. But that policy should remain in place until the new local plan's been adopted. So I'm sorry to say, I mean, you can try and word, you're clearly trying to word out answers out of me. But my position is not going to change on the fact that we had a policy that was enacted by the council, and that's the policy that we should adhere until any formal new local plan has been adopted by this chamber. And that is my position on it. Yeah, and it should be everyone's position on it.
I'm trying not to interrupt you because the answers you're giving are no doubt helpful to the inspector in the context of a number of things. But just so I'm clear, you said democratically elected. You appreciate the national government was democratically elected. And from 2018, the last government and this one identified a much higher housing figure. So what the council's been doing is ignoring the democratic requirements of the government to meet the housing needs that are identified, hasn't it? You've been ignoring the democratic process at the national level.
No, because the new local plan will address those issues. But the council's not always in a position to keep producing local plans as it wants. Some local authorities are a little bit more swifter at it than others. But this local authority is not in that position. But it has a great opportunity now. Like you said, there's a newly elected national democratic government, and the new local plan will probably reflect that.
Yeah, Councillor, from my client's point of view, there's probably little or no chance of you producing that plan because you've said it before and you've got no credibility. That's our position. Your position is different. You hope you're going to achieve it. But just help me with this, please. As of 2018, the government required local authorities not just to have a development plan, but to have an updated development plan. That's set out in the MPPF in paragraph 11, 12, 15, and so on. You haven't got an up-to-date plan, and your housing requirement figures become out of date after 5 years. So will you accept that your local plan and the green wedge policy in it are not up to date?
The local plan might not be up to date, but I believe the local wedge policy is.
Okay. Do you understand? Sorry.
So I just check. Obviously, we'll come on to the council's formal witness in due course. So these are covering a lot of ground that you potentially will be covering.
I've got different questions for the councillor, but look, if you don't think this is helpful, I can stop.
I think I've probably heard all I need to in this context with this particular witness.
Fair enough. Thank you, councillor.
Thank you. Thank you. Should we take a brief adjournment and come back to hear from the remaining two interested parties at 11:30, please? Thank you. take to the stand. Thank you. And again, can I presume hard copies will be circulated in due course of your script?
Yeah, that's right, sir, and they're going to be uploaded.
Thank you. Okay. In terms of ID documents, you say 1204 for Councillor Smale, once it gets given to us, and 12.05 for Councillor Wright's script. Okay, yeah, in your own time, please.
Okay. Yeah, first of all, thank you for giving me this opportunity to speak to the inquiry. I'm a long-standing resident of Spondon, and since May 2023 have been a city councillor for the ward of Chaddiston East, which forms the other boundary for the Chaddiston-Spondon Green Wedge, in which the Royal Hill proposal lies. It should be noted from the outset that green spaces and parks are at the heart of Derby's identity. Indeed, Derby Arboretum, established in 1840, is recognised as Britain's first public park. The application to build on this site was rejected by Derby City Council Planning Committee as it does not meet the requirements of the local plan, in particular CP18. This is not without precedent. Previous similar applications for this site have been rejected for the same reasons, rendering the site inappropriate for residential development. I consider that other core principles are contravened too. CP16, green infrastructure. This principle states the council will seek to maintain, enhance and manage Derby's green infrastructure. This application does nothing to improve green spaces. It merely tries to limit its impact. This principle seeks to enhance, not degrade green wedges. Specifically at item D, states the council will identify green wedges as areas of land that defines the city's neighbourhoods and seeks improvements to enhance the wider green infrastructure. The current local plan remains the local plan for decision making. It is recognised, however, that the tilted balance and presumption in favour of development applies, as the city does not have a 5-year supply of sites for housing. The new local plan, however, will not reach Regulation 18 public consultation stage until January 2026 and then submitted as a Regulation 9 plan by December 2026, so currently holds little or no influence over planning decisions. Recent public feedback from my own ward to a proposed development on a former farm demonstrates opposition to new residential developments on countryside that penetrates into the city. So, the contents of any new plan is currently speculative. The housing requirement in the local plan CP6 was and still is not being met due to a lack of housing sites. So paragraph 11D of the MPPF requires that where there is no 5-year plans means granting permission unless the conditions of 11D are met. Derby's green wedges, in my view, fit into the definition of local green space described in paragraphs 103 to 108 of the MPPF 2024 and thereby fulfil the requirements of 11D1. I recognise that the housing land supply of 3.85 years is a significant shortfall and therefore very significant weight was applied in favour of this application that it could have contributed to increase in supply. However, on balance, the committee found it was not sufficient to tilt the balance in favour of development. The MPPF says the development should be refused if policies within the MPPF provide a clear reason for refusing. One of the policies the MPPF is referring to is green spaces, and this reason is prominent in the committee's decision for refusing planning. The application failed the first test, which is enough in itself, but it failed the second test too. The second test that any adverse impacts of approving development would significantly and demonstrably outweigh the benefits. Here, the report to the committee itself identified many disbenefits: loss of the green corridor, congestion, insufficient local infrastructure, etc., with the only benefit being the housing. Also, 116 objections from local residents too, as did the Campaign for Protection of Rural England. Although the tilted balance was applied, it was not sufficient to grant outline planning permission. I and other objectors recognise the city needs to plan and provide suitable housing sites that are deliverable to accommodate many new homes in a new local plan. This 90 could make a small contribution, but not at the expense of contravening the fundamental principles of the plan, which is creating a city with the green amenities that make it a home for people and businesses rather than just bricks and mortar. Officers have commissioned a Green Wedge Green Belt review for an independent test, which is hoped could be relied upon in validating choices for allocations to both objectors and developers. However, the results of the study are not available for you to consider. The recent decision of the Planning Committee, which I referred to earlier, is not unique. You know the decision relating to Acorn Way, which others have referred to in detail. I submitted to you on the 31st of January this year the remaining details of 2 previous applications to build on residential housing on Green Wedge land at the same location or nearby to the present refused applications. Although both these applications are historic, 1976 and 1985, they both state the reason for failure as wedge land between the 2 communities that approval for development would set a precedent that could lead to the gradual coalescence of 2 distinct residential communities. The later refusal also states the application is contrary to the local plan and city structure plan. These reasons are consistent with the 2024 decision of the Planning Committee. For the last 50 years, the Council and residents of Derby have consistently recognised this particular small but important wedge or lung of the city needs to be protected, not just as green space, but to support the wider policies of the Council to maintain the distinct identities of communities. A counter-argument to this proposal is that many things have changed within the last 50 years, including the need to build more housing for Derby. This is true and a powerful argument. However, in Spondon, over this time, significant numbers of new houses have been built, contributing to the city's housing need. Another issue to be aware of is over this period, Spondon's infrastructure has not expanded to meet the impact of additional housing. The roads, the drainage have remained largely unchanged, as have other key services for residents, the schools, surgeries, etc. Returning to the adopted local plan, in its introduction, the then chair of planning states, Derby has valued areas of green space more important than ever. That is still the case in 2025. It is worth noting here that Spondon's green infrastructure is also under threat from the successful Spondonwood application in Erywash, seeking to build hundreds of new houses near Royal Hull Road on designated green belt. Spondon residents are having their green spaces jeopardised on all fronts, and although the Derby Planning Committee could not influence that decision, it did, in my view, fully consider the implications of the out-of-date CP6 and considered other relevant core principles, the NPPF and other legislation and guidance in their public meeting. In summary, I propose that the committee's decision was well considered and compliant with legislation, guidance, planning and public opinion. Thank you.
Thank you very much. Councillor, good morning. Can I just ask, were you on the committee that made the decision in this case?
Yeah, I'm sorry, could you just repeat your question?
Yeah, sorry. Were you on the committee that determined this application?
I was not on the committee. I'm not a member of the planning committee, but I was present during the committee here and gave evidence to the committee.
Yeah, so you were not part of the decision-making. You were making representations on behalf of your constituents.
Yeah, I was making representations on behalf of my constituents,
yeah.
and also as a councillor of the city representing the views of the council.
Yeah, I want you to keep the microphone on, by the way, for the purposes.
Okay, thank you for that. And then can I just ask you then, obviously you approached this on the basis that, you know, local people opposed this proposal, but you've also talked about recognising the council hasn't got a 5-year supply. You recognise that, yes?
Absolutely, yes.
And you recognise the position with regard to the green wedge. You recognise that it's treated as out of date. Are you aware of that?
And so it triggers?
Yeah, I'm sorry. So the green wedge policy, do you recognise that that policy is out of date?
No, I do not.
No, okay. Do you take responsibility for the fact the council told a planning inspector it would produce a Part 2 plan, small sites allocation, small as in not strategic, by December 2017, and it didn't? Do you take responsibility for that?
I personally don't. I wasn't a councillor there. I became a councillor in 2023. I'm aware that we haven't got that Part 2 plan, and as a city councillor, take corporate responsibility as a councillor. I'm aware of it, but not personal liability. And I'm mainly here to represent myself as a resident of Spondon, but also as a councillor for Chaddiston East, which is borders the other side of this green wedge, whose views I think are very important to form part of this discussion.
Yeah, and so, Councillor, in that context, do you recognise that the council is the author of its own misfortune, in the sense that if you had an up-to-date plan and it planned for the housing that was required and it reinforced green wedge, for example, and that was accepted by the inspector, you'd be in a much different position. Do you accept that?
I'm not an expert in planning. I consider myself a diligent councillor, so I listen to all the debates in the planning committee. I've read as many of the documents as I can. Having been given evidence at other inquiries recently in my very short time as a councillor, I am aware that planning is a very, very complex issue, even for people that are interested, and for the average member of the public, trying to navigate their way through the complexities of planning is very, very challenging. So I wouldn't determine myself an expert, but in my interpretation, that's what the National Planning Framework for is, that where councils haven't got or can't meet their targets, that there are ways that planning can be moved forward. So as far as and planning is complex, running the city council is complex, and you've already heard evidence, the constraints we had in Derby we have got in terms of building, and we have to go outside the city boundaries. So I don't think it's as simple as your question.
I don't doubt that you are a diligent councillor, and from what you're saying, people step forward and who would do that? Put yourself forward and perform this role to represent people. I'm not questioning that, but you said you're not an expert in planning, and this is a planning inquiry. It's based on obviously evidence. That's what the inspector is going to consider. The council could have produced an up-to-date plan addressing its housing needs and redesignating land as green wedge. It hasn't done that. And that is the responsibility of the councillors, isn't it?
It is. It is responsible of the councillors. But again, I also think there's a method to mitigate that issue, because Derby's not unique in not meeting its planning targets. And, each council is unique in its own way of dealing with that. And my understanding is that's why the tilt of balance comes in, so that those where councils aren't meeting the objections, a decision can be made by the planning committee to actually determine whether it's a suitable site or not.
Yes. Now, I would suggest to you that when you haven't got an up-to-date plan and you haven't got a policy that's up to date, and you've got a big shortfall in your 5-year land supply and your affordable housing living, then the answer would rather suggest that you grant planning permission. Obviously, the councillors took a different view. It wasn't a view shared by the professional officers, but they took a different view.
Can I just make a point there? Yeah, it's not, but it's the officers' role to actually provide the option, provide the advice, but it's the council's decisions to make the decision. Absolutely.
The professionals took a different view. But isn't what's really going on here is that as a councillor representing local people, all the people who have objected who own a home, usually quite close to the site. And the people who don't have a home, can't afford a home, can't get an affordable house, they're not your they're not the people that represent you because they want to move into this area or they want an affordable home. So what we've got is an asymmetrical planning system where you as councillors obviously have to listen to your local people, otherwise you won't get elected next time. But we're not really listening to the people for whom the houses are actually intended, are we? What's happening is, you made a decision contrary to the professional officers, but you did that because there was a big petition. That's why you made the decision, wasn't it? Sorry, you're absolutely right. That's why the councillors and why you objected, because you're articulating the views of existing homeowners. That's what the planning system is.
Yeah, I mean, I understand your point. I did take the opportunity to look through of all with the documents this morning, and although your assumption is largely right, there's a lot of objections, not just from local residents, from people further afield, from professional organisations. I mentioned the Council for Protection of Royal England, for example. Yeah. So largely, I take that point. But that's not the only way that we listen to local residents. I mentioned in my evidence that residents of Chadderton on the ward, they are directly affected because their housing, their interests are right on the other side. A lot of residents of Chadderton, their children go to school in Spondon. They use the facilities, they use the nature reserve, for example, so they are directly affected. They might not have objected, but if you go and visit our Facebook site, you'll see a lot of conversation about housing in this vicinity of Derby. So I do take your point, but it's not. And in terms of the homeless people, we get feedback from a whole range of other reports to council in terms of the impact of housing. So it's not, it's not just a simple the number of objections that are raised.
If I may say so, you addressed that point very fairly, councillor, and I'm not going to trespass on that. Also, just to sort of put the number of people objecting into context, I think something like 115 people objected, but the population of Spondon is around 12,000. So on that basis, it's a tiny proportion of people, and we've had a look at the addresses. It's the people who, most of them are the people closest to the site. So what this is like a private objection in a public planning system.
Yeah, in terms of your right, statistically, 117 is a small proportion of overall population of Spondon. However, I know from my own personal experience and talking to residents that most residents are not very keen to actually put themselves forward, although they may express their views on the doorstep, and I can talk for personal experience, talking on the doorstep to people in Royal Hill Road area, there's a lot of objections, but they also rely on the councillors, particularly the Spondon councillors, to put their view forward.
Is it fair to say that many of the people objecting here today are retired people, or people over the age of 55, or let's say 60, and many of them are existing homeowners? Would that be a fair reflection of the people objecting?
There's a certain amount of supposition in that statement as well from your behalf, isn't there?
Oh, complete supposition, yeah, but that's why I'm asking the councillor, because he'll know. Isn't it right that a lot of the people who are here and a lot of the people who have objected are existing homeowners whose houses were built on greenfield land, who are retirement age?
I personally, obviously the people here, I would agree with you. I mean, that's self-evident. But in terms of the objectives, I've got no way of knowing the people who made their objections, of how old they are, whether they actually own houses or not. That would require a different piece of analysis to be able to answer that question correctly.
Okay. Councillor, just last question is, do you recognise, it's in the Telegraph today, do you recognise the unfairness of the older generation homeowners making it more difficult for younger people to acquire houses and start families and have their own home. Do you recognise that that's what a lot of this objection is doing?
I don't know, not at all. I would say that the people who are making the objections are making objections based on their own understanding of the proposals being put forward, their own views. I would anticipate, certainly the people I speak to on the doorstep, my own residents, they're all very keen on making sure that their children and grandchildren can get onto the housing ladder and want to make it as easy as possible. Building out, and owning your own home is not the only way to get onto have accommodation. There are other ways of doing it. So I think we are very much focusing on making broad generalisations in relation to this specific issue.
Yeah, we're going to get into the detail of the policy and the effect of the tilted balance and so on. But just on your last point, you say, well, look, people all recognise the need for new homes for their children and their grandchildren. But what we usually see is what we're seeing here is they just don't want it near them, do they? That's what's really going on.
No, I don't think it is. I mean, I know of housing developments in and around Derby that have gone through. I've personally, I've been a resident in Spondon for a long time, and there's been housing developments in Spondon that I've not objected to because they've been in the right place with the right level. There are ones recently, like this one, that I have objected to because of the nature of the proposals put forward on the green wedge, basically.
Okay. Councillor, thank you very much.
Thank you.
Thank you.
Just for confirmation, I have a printout of your scripts, and there's an accompanying part of the local plan you're going to refer to in the script. Okay. Okay. I'll treat them as one in terms of giving them a reference number of 12.06.
Am I on?
Yeah, you just have to press the button on the bottom right there.
The meeting. Oh, that's sorry. I apologise.
You can leave it on for any questions as well. But in your own time, please, Mr. Palmer.
Yeah. Thank you, sir, and thank you for giving me the opportunity to speak at this inquiry. I want to just point out, first of all, that I'm not a councillor. I'm not and have never been a member of any political party. As far as I'm concerned, my dealings with this are as a resident who lives near the site, the ordinary person in the street, as it were. And that was even made more interesting this morning as I came for the bus, because a chap who I don't know, in his 30s, not over 55, but I would imagine in his 30s, who actually commended some work that had recently been done in the Century Garden in Chapel Street, and I mentioned I'd been involved in that. I said, well, sorry, I can't talk, I have to go to a public inquiry. And he said, oh, is that the one that involves the green wedge between Spondon and Chaddiston? He says, it's ridiculous anybody wanted to build on there. We need to keep our communities separate. And the opposition on this is not Spondon versus Chaddiston people. It's a question of maintaining the gap between the two communities and so preventing coalescing and urban sprawl. I want to stress that residents are not NIMBYs, but any housing in Spondon or elsewhere has to be the right homes in the right place as far as development plans go, and this plan does not meet that. I refer to the Spondon local plan of 1989, which I've given passed around here. It says that the land between Chaddiston and Spondon is shown in the 1958 development plan. That's 9 years before Derby's boundaries were extended to take in Spondon and Chaddiston amongst other places, as white land on which the existing uses were to remain predominantly unchanged. So that's 1958. Quote, the City Council has managed a consistent policy of retaining the separate identity of those settlements which were originally separate from the historic urban core. And this policy of retaining an open wedge of land where uses are of an open character has accordingly been applied in this area. Quote, there has been a long history of refusal of planning permission for development in the wedge area stretching back to 1957, when an application for residential development was refused partially on the grounds that the area was required for the creation of an effective open wedge between Spondon and Chaddiston. And so it's gone on. All applications have been refused by the City Council, and certainly this one last year, rightly in my opinion, as have appeals against those rejections. The green wedge is only 500 metres across, so building on it will make this green corridor even more narrow, defeating the object. Effectively, it was decided that any application for housing in Spondon should be infill development within the built-up area. And so it has been. This is included on green sites such as orchards, the cricket club and the garden nursery, and brownfield sites, at least 2 factories, a scrap and waste area, a caravan centre, bank and convenience store, a former bus and car park for Celanese workers, and demolished blocks of flats. The last development by Wheeldon Brothers even involved building on land off Nottingham Road beneath pylons which people said would never be built on, but they're no longer operational. We have had our fill. There is no space left apart from these fields and Greenbelt to the east of Spondon. I quote from the Council's Green Wedge Review of 2012, which says this land provides a vital break in the urban landscape, helping to reduce the feeling of urban sprawl, providing residents with access to the countryside and space for recreational activities. It also provides a haven for wildlife. It is a green lung within the city, helping to mitigate the impacts of climate change, and I'd personally add air pollution, which can be poor given the nature of the A52, rail and industry. It provides space for agriculture and is one of the most actively farmed areas of the city. It contributes towards the mental and physical well-being of residents. But sir, I think I hold a unique place in this inquiry, as I believe I'm the only person here who, as senior local government correspondent to the Derby Evening Telegraph newspaper, was present at the meeting in the 1980s and reported on it when this green wedge was formally adopted by the City Council Planning Committee as a policy, as either the first or one of the first in the city. That policy on this green wedge was not for 6 months, 5, 10 or even as now 40 years. It was intended to be forever, unless and until councillors decided otherwise. This acknowledgement and respect for open green spaces in the industrial city of Derby was momentous, particularly as south of the railway line there was one of the largest industrial complexes in northwest Europe, plus other industries and an incinerator nearby. And that, sir, is the crux of the matter. Who governs Derby? The decision on this and other green wedges were taken by democratically elected councillors with the city's interests at heart. They are responsible and accountable to the electorate, the ordinary hard-working men and women of the city who like to enjoy such spaces. In our democracy, it is council who make policies and with the help of officers guide development, which says where housing and other land users, bearing in mind infrastructure including roads, should go. It is not for house builders, developers or landowners to decide or dictate where planning permission should be given for homes, or to ride roughshod over democratically decided policies in a cavalier manner, creating a higgledy-piggledy effect just so that they could make a profit. Companies are not responsible to local taxpayers but to shareholders, and in this case Miller Homes is owned by US asset management firm Apollo Global Management. While the policy of the Green Wedge is paramount, a major concern of residents, not just on Royal Hill Road but also on adjacent Locker Road and further afield, is traffic. As someone who's had the pleasure of living in Spondon all my life, I've seen how the village has grown, and with all the various developments, so has the amount of traffic. We're not just talking about cars, but buses and heavy vehicles such as juggernauts, bulk carriers and car trailers making their way through the narrow streets and past even more narrow pavements in Sitwell and Moore Street to a warehousing site at West Hallam. There is lack of car parking in the village, made worse by some drivers from other villages coming to Spondon and getting on buses to Derby city centre, because the buses can avoid some of the many hold-ups and problems of finding car spaces. At morning rush hours, there are traffic queues on Dale Road, Moore Street, Sitwell Street and Willercroft Road, which is effectively the main exit to Derby city and city centre and other places. That can actually then back up from Churchill into Church Street and nearby. Royal Hill Road is narrow and has people parking cars and larger vehicles on both sides of the road and even on pavements and green verges, so that often a motorist has to drive along the middle, give way to oncoming traffic and then drive in a slalom manner. Royal Hill Road itself has 73 homes. 6 houses do not have gardens or driveways to park cars, and there are 13 properties which have white lines on the road because occupants have disabilities or other access issues. 90 homes is almost as many as the 100 homes on the 3 cul-de-sacs, Windmill Meadow, Marina Drive and Charles Avenue, which have to access an egress via Royal Hill Road, the only way to the main Locker Road. If residents of 90 planned homes have just 2 cars, this alone would be around 200 or more vehicles making journeys along Royal Hill Road, which is unsustainable. That does not include visitors, delivery vehicles, refuse lorries, emergency vehicles. But traffic issues are not just confined to Royal Hill Road. Locker Road is a busy spine road. There are 7 homes on Mill Row, about 100 yards from Royal Hill Road, whose occupants have to park on Locker Road. Next door is the Vernon Arms pub. It does not have a car park, so again customers, including those attending wakes and other functions, have to park on Locker Road. On Saturday afternoon, I found 18 cars parked there, with another 13 opposite, half parked on the pavement, causing problems for people trying to get through. A few yards away is a busy light-controlled pedestrian crossing close to the staggered junction of Lockwood Road, Chapel Street, which leads into the village centre, Church Street and West Road. This junction is in the village conservation area. Excuse me a second, sir. Within 200 yards, there are 3 schools, which I understand is the highest concentration of such in all Derby. These are a senior and 2 primary schools, accommodating 2,100 pupils and staff. West Park Secondary has 1,460 pupils aged 11 to 16 and 200 staff, most of whom travel to and from work by car along West Road, as do some pupils in parents' cars. Springfield Primary School, almost opposite, has 40 staff, again, most of whom travel by car. West Road itself, a dead end, is one of the most narrow in Spondon. At its most narrow point, it is just 122 inches across and so can take only 1 vehicle. In addition, there's a relatively new footpath from Springfield School that comes out of the bottom of Royal Hill Road near Marina Drive before the road bends round to the right, where parents park to drop off and pick up children, doing three-point turns in the process. I was shocked when I visited the site before 8:30 on January the 17th and saw the number of vehicles involved, parking right round the bottom length of Royal Hill Road, including actually reversing into the drive of the landowner of these fields, but also in Marina Drive and Charles Avenue. In addition, St Werburgh's C of E Primary School has an access for staff on Church Street. There is also pedestrian access on Chapel Street, and some parents park in the grounds of the old school opposite to drop off and collect their children. All this means that at times there is gridlock with traffic in and around this staggered junction and the roads leading to it at a standstill, which can last for some considerable time as the different schools stagger their morning arrival and afternoon departure times. Depending on other factors such as roadworks, gridlock can turn into chaos, causing particular problems for emergency vehicles trying to fight their way through when seconds can be vital in saving property and lives. 2 weeks ago, I witnessed a massive juggernaut turn from Church Street into Chapel Street, where there were contractors' vehicles blocking the road. The driver then turned to back out just as kids were coming out of St Werburgh's Primary. One parent guided the juggernaut onto Locker Road, while I tried to discourage people from crossing in case the vehicle jumped. This took several minutes and caused more gridlock, especially as the juggernaut then tried to go down Church Street, which has double yellow lines on one side and no pavement the other. Excuse me, I put in extra paragraphs there, sorry. St Werburgh C of E Primary School has an access for staff on Church Street to park. There's also pedestrian access on Chapel Street, and some parents park in the grounds of the old school opposite to drop off and collect their children. So there's a heavy mix of large number of pupils, particularly younger ones, with accompanying adults trying to cross these busy roads in addition to all the vehicles. The thought of another 200 cars trying to get up and down Royal Hill Road and on and off Locker Road, particularly at peak times, is horrifying, impractical and unsustainable and will make a bad situation far worse. Sir, I have provided photos showing traffic issues, and I would urge that when you visit the site, if possible, to do so at a time of a school run so that you can see the issues for yourself. I live there and know on a daily basis what happens. Indeed, as I got on the bus, I spoke to somebody who, hearing about this inquiry, said, "Oh, when they're going to visit them?" I hope they're visiting at a good time and see things because they might see me on my walking frame trying to get through all the parked cars. This is important because I'm given to understand by locals, I stress that was told me, that the traffic consultants for Miller Homes in their original report attended the site during school holidays. I do not know if this is true, but if so, then it's against the guidelines or give a very distorted picture. I think you also have a petition signed by those who drop and pick up children at the footpath leading to Springfield School, telling of the problems and how these would be worsened if the scheme went ahead. I should also add that paragraph 8.4 of the summary and conclusions of BWB Transport report is totally inaccurate. It says that the site is accessible by public transport via the S2 shuttle bus. Excuse me, sir. That was a trial which ended last year after a short period, so no longer applies. The nearest bus stop currently is in Sitwell Street, well over double the 500 metres suggested in the report. Walking from the furthest part in a development would take the best part of 15 minutes to the bus stop, and I would not like to carry shopping bags and walk in the rain back up Chapel Street to reach that starting point. There is the added question of air quality. Yesterday it was listed in Spondon as poor. Quote, "The air has reached a high level of pollution and is unhealthy for sensitive groups," unquote. This can only be made worse by building on fields in a green lung and putting extra vehicles on Royal Hill Road, particularly heavy construction lorries, if permission is granted. The applicants say the approval would help meet the council's target. Actually, there are around 5,000 homes in Derby which have planning permission, but no work has yet commenced. The council and developers should consider other sites, both greenfield and brownfield, in the city, and not pressurise an already built-up suburb and intrude into the vital green wedge. I quote for a statement from Miller Homes in the Derby Telegraph, quote, "Land off Royal Hill Road, Spondon, will be a highly desirable place to live, reflecting the desirable elements of the local vernacular." This last phrase is the most meaningless marketing gobbledygook I've ever heard. Importantly, it will be not desirable to live there if people cannot get up and down the road because of traffic congestion, or not be able to use the already hard-pressed facilities, doctors, dentists, and everything else in Spondon. This continues. The proposal respects the local character, but also move the community towards a more sustainable future through a significant increase in housing choice. Again, more utter rubbish which does not stand up to reality. There is no respect for the local character. It does not say which community will have a more sustainable future, and the increased housing choice is not much when you consider that until the other week there were 90 homes, interesting figure, 90 homes for sale in Spondon on Rightmove. Even on Friday, there were 76, 6 of which are on the market at more than £400,000. There is enough choice already. But in fact, that choice is even bigger now because of a possible exodus. One couple on Marina Drive have already sold their home and left. I was told they didn't like the current situation with cars parking outside their house, but feel that the extra traffic would make life unbearable, and they were leaving now while they could. And that was before prices would be knocked down. People are worried that if this plan is approved, it will be only a short time before Miller Homes or another developer comes forward with an equally absurd argument to nibble away at another stretch of the green wedge. There could be a domino effect which could also send ripples against the other 12 green wedges in the city and beyond. To sum up, this controversial application, opposed by many people, is neither needed or wanted in Spondon. It goes against all previous decisions and principles over decades. It will erode the important green wedge, increase traffic problems and put pressure on local services. These outweigh the so-called benefits which local people think are both invisible and risible. So I would urge you, sir, to dismiss the appeal. Finally, I just want to say this is nothing personal against Miller Homes themselves. I would similarly oppose plans by any other house builder company. I am actually just keen to save the heart and soul of the village where I have lived all my life.
Thank you, Mr. Palmer. Before I come to Mr. Young with any questions he may have, just to pick up on the point that you raised there, or the request you suggested in terms of visiting the site during term time when there's school collections and deliveries and so forth. Obviously, I know we're in the school holiday period at the moment when my site visit is anticipated to take place.
Sorry, I didn't hear, sir.
Yeah, I'm aware that the site visit I'm scheduled to take will be this week whilst we're still in the Easter break. But I am conscious of the point you've made, and I think it comes through in a number of the interested party representations that have been made. And I did want to say that I will be in the local area, or certainly the region anyway, in the next couple of weeks when the term time will be when we're back at school after Easter holidays. I was going to suggest potentially doing a visit to the area to coincide with one of those peak times, if it was going to be agreeable to the parties. Mr. Richards?
I would.
Yes,
I think I would appreciate it, and I would be happy to meet there and show you anything, etc.
Well, that wouldn't be it would be the case. It would have to be on an unaccompanied basis.
Oh, right,
be
sure.
representation.
Yeah.
If everyone was happy.
If you wanted.
That's what.
I was about to say, I assume that would be unaccompanied.
Yes. Yeah. I didn't know whether we wanted to agree the times or the windows that would be of most relevance in terms of when.
Yeah, I mean, I think it would be fine. So first of all, I would endorse that because it's an issue, and then nobody can complain that you haven't seen it under those conditions. I think it's better in those circumstances that inspectors go unannounced, as it were. So long as you go at the relevant time, which I assume is sort of 8:30 to 9 o'clock in the morning, subject to what the gentleman says, then you can choose the date.
We'll get the date when the schools go back locally here. B, we will double check that none of the schools are, as sometimes happens, having the first day back as a teacher training day, and therefore the kids aren't in. So we'll double check that sort of thing, just so that we know that you're going to visit on a normal day.
Can I just point out, sir, that West Park Secondary School, I think, starts at 8 o'clock in the morning. As I say, the different schools are staggered at their times. So they're at 8 o'clock, so you get the traffic building up and that before then, and then also the children at the other schools, I think the primary schools go in at 8:30 or 8:45 and that sort of thing. But similarly in the afternoon, the West Park finishes at 3 o'clock, again with the primary schools coming out after that.
Okay. Well, on that basis, it might be that a morning peak might be defined as 8 till 9 and the afternoon peak 3 till 4. If I was to be in the area.
Whichever side. Just wanted to. I would hate to think of you turning up at 9 o'clock and then finding that everybody was sitting there doing their geography lessons, you know.
Okay. And yeah, I had given thought to Mr. Richards' point about schools going back and potentially there being a teacher training day or something, but I think it's the 22nd is April, the 22nd, obviously the week today on Tuesday, I think, is when they're scheduled to go back, but yeah, confirmation in terms of any restrictions that might apply that.
We'll interrogate some websites for you.
And yeah, if anyone has any dispute on those hours that I've said, you can obviously raise it at the inquiry if you think it should be. Yes, Mr. Councillor Smale.
So I do apologise. From a declaration of interest, I am the chair of trustees for West Park Community School, and I can confirm that they will be back at school next Tuesday.
Okay. Yeah.
So I know the residents and other people would be grateful for your appearance at these times, the rush hour times, sir.
Yeah, I won't confirm the precise date, but I will certainly await confirmation in terms of when we're back after the holidays.
Do need to see it for yourself.
Okay, can I come to Mr. Young then, if you have any questions?
I don't tend to ask local people questions. They obviously want to say what they wish to say. And on the highways issue, we've obviously got BWB's report and no objection from the Highway Authority. So, you know, that's the evidence I'm going to rely upon.
Just one more point I was going to just clarify, I think we'll come to later in the evidence, about the bus stop on Locko Road, I think is the closest one. And I think Mr. Palmer was intimating that there's no buses served by that bus stop presently.
No, there aren't.
Okay.
There are not.
Yeah, I don't doubt that he's right. So for your note, in the transport assessment of July 2023, paragraph 8.4, page 42, there's reference to this Ilkeston flyer service and the distance from the bus stop being 500 metres. I'm sure the gentleman's correct. I'm sure it sounds like it was a service that was
That's totally wrong.
Yeah, that it's been withdrawn. What I understand is that there's new services coming. But I'll get Mr. Lees to deal with that when he gives evidence. But I'm not doubting what this gentleman's saying, and I'm just helping. He referred to the BWB report, and I think that's probably what he was looking at.
Just in the interest of, are you aware of any new services coming?
There is a new service, but I don't think it's going along the road at that point. And although this is supposed to be started to, there's a lot of confusion in the village because people don't know exactly, although there is a date when it started, there are no timetables published or anything, or the precise actual route. We've got an indication where it's coming.
Okay.
But that's it.
Okay, any final point on that from, you said what you need to.
Yeah, I mean, we'll double check it and see where it's going and see which one should be the right information.
Thank you. Okay, thank you. I've heard all I need from you, Mr. Palmer. Thank you for your time.
Thank you, sir.
If you wouldn't mind turning the microphone off as well. Perfect, thank you. Okay.
They didn't used to have all this technology when I used to sit on the press bench.
Okay, if we go to the, I think we've probably got time, unless the parties feel differently, to potentially go through evidence in chief with Councillor Holmes.
I think we have. Yep.
Yeah.
No, I think we have.
I think we should do that then, please. Yeah, there's estimated 40 minutes, which would take us to around 1 p.m, and then we'll have our lunch recess. Yeah, please proceed whenever.
I was about to say, Councillor Holmes, if I put my microphone on first and then you put yours on, I get overridden and you appear on the screen. So we've got that the right way round. Are you Councillor Matthew Holmes?
I am.
Yeah. And you've provided, I think, a proof of evidence in this, for this inquiry, haven't you?
I have.
Yeah. And have you read it more than
have.
once? And recently?
Yes.
Okay. And you're not on oath, you know, you're not swearing to tell the truth, the whole truth, and nothing but the truth. But have you included in your proof of evidence what your opinion, honestly held opinion is?
Yes.
Good. And that's what you say at paragraph 1.2 in your proof. And will you apply the same understanding to what you say now to the inspector orally at this inquiry?
Yes.
Now, we know, because you tell us, that you were first elected to the City Council in May 2008.
That's right.
And you sit on the Planning Committee.
I currently do, yes.
Yeah. And you were sitting on the Planning Committee the day that this planning application came up before the committee.
I was.
Yeah, and we know that from the minutes of that meeting, which the inspector has at core document 3.03. You can probably remember, Councillor, without going to them, but the minutes record that, first of all, the development control team leader, the planning officer, addressed the committee, talked to you, and no doubt talked her way through her report. And then it says that Mr. Lees from Pegasus Group, for the then applicants, Miller Homes, he spoke to the committee. And then Mr. Kevin Palmer, who's just been sitting up there, spoke to the committee. And Councillor John Wright, who we heard for earlier on, spoke to the committee. And then the minutes record that having heard all that and read the committee report, the committee decided to disagree with its officer's recommendation and instead of grant permission, to refuse permission.
It did.
And there was only one reason for refusal, that eventually worked its way onto the refusal notice.
Correct.
But it is recorded in the minutes. And then, once the committee had resolved to refuse the permission, it immediately went on to resolve that you would be nominated to represent the committee at any future appeal. Is that the way that the situation works in Derby? If the committee resolves to refuse an application against officers' advice, the very next thing that happens is that somebody on the committee is nominated that if there's an appeal, they'll be the person who comes to explain to the inspector why.
That's the process.
That's the process. And does that happen very often?
No. No, it doesn't.
I mean, can you recall the last time it happened?
For an application of this size, a larger housing development, I can't recall the last time the committee went against offer recommendation or refused. This is quite rare.
Yeah. And have you ever had to give evidence before at a public inquiry like this in those circumstances?
Not in those circumstances. I've been nominated a couple of times on various applications, but this is the first inquiry.
Right. Okay. What sort of training do you get as a member of the planning committee?
So after the annual meeting of the council, when committee membership and board memberships are agreed, then councillors will have training with the relevant officers for those particular positions that they are given. And also the planning committee meets approximately every 6 weeks. And currently Derby City Council, and has done for a long time now, has planning sessions an hour before each committee, which would be topic reviews, latest information on NPPF's changes, etc., planning policy, and reports and presentations.
Right. And then, do you sit on any other sort of committee, or are you a sort of planning specialist amongst the elected
No,
council?
I've got regeneration and also the exec scrutiny board I sit on as well.
Right. But you don't sit on licensing matters or anything like that?
No.
So you don't get licensing training?
No.
No.
I mean, we can, I think the opportunity is there for us to sit in on relevant training if we want to, but obviously it's important that if you are put on the planning committee that you get the relevant training, for example.
Now, in this case, we know that the reason for refusal relates to the green wedge.
Yes.
But there is a statement of common ground which is at core document. I did have it open on my screen. 8.01, yes. Have you got access to core document 8.01, either on your...
It's over there.
The statement of common ground?
Yes.
Yeah, do you want to make sure you've got everything with you?
Okay. Is that okay, sir, if I fetch that? Thank
Yeah,
you.
just scoop up everything you've got. And then I know you've got your laptop there. Are you also logged into the application page? So that if I or Mr. Young or the inspector wants to ask you to look at a particular document, you can click on it if you haven't got a hard copy of it.
Statement of common ground is here.
Yeah, that's right. And it should have been signed on the front page by you.
It is?
On the 25th of February 2025.
That's right.
Yeah. So this is a document you've seen before, is it?
Absolutely, yeah.
Okay. And then just to go through it, it's got a number of chapters. And it includes a series of matters which are, first of all, agreed. So we can see that there's a section headed out of date policies, policy CP6 on housing delivery. That's agreed to be out of date because the numbers are out of date, essentially. And then under CP18, it's agreed that the green wedge designation contained with policy CP18 does not offer protection from the tilted balance, as per the current NPPF. That's not written into that policy. Okay, good. And there's then at the very foot of page 12, paragraph 8.13, we get to a list of the scheme's benefits, which all have to be weighed in that tilted balance. The large number of new homes in a sustainable location. You accept that. Affordable housing, which will be provided in the context of a very significant housing need. You accept that. On-site provision of biodiversity net gain, you've agreed. New accessible public open space through landscape planting and habitat creation. As you understand it, if this scheme was built out and public open space was included on it, would there be a customs check checking that only residents of the new houses use the public open space, or would people in the neighbourhood be free to come and go to the public open space as well?
Unrestricted.
Unrestricted, yeah. And then it said that there are temporary economic benefits from the construction through job creation and economic investment infrastructure. And then the contribution towards the provision of a bus service. All of that agreed.
Yeah.
Okay. And then at 8.14, just one disbenefit or harm, and that's the green wedge.
Correct.
And that's the balance in this case.
Yes.
And we know from the officer report that the officers did precisely that balance. The reason for refusal only mentions the green wedge. Does that mean effectively that you agreed with the officer report on everything else other than the green wedge issue?
Yes.
Okay. So that if the inspector wants to know what you think about highways, for example, the inspector's entitled to say, well, the members of the committee and Councillor Holmes in particular agreed with the advice that they were getting in the report to committee. And then there's some further detail given about the affordable housing in the Statement of Common Ground at paragraph 817. Where the need is described there as being extremely significant. And that there's reference to an additional statement of common ground, which we also have. And then biodiversity, the numbers reported, same from the committee report, reported in the statement of common ground as to what those net gains would gain to be. Heritage. It's agreed that there aren't any designated or non-designated heritage assets located within or adjacent to the appeal site. The fact that there's being no harm caused to heritage asset, is that a benefit that you think the appellant needs credit for, or is that neutral so far as you're concerned?
Takes neutral.
Right. Okay. And then again, a lack of pollution, air quality, noise and lighting. And at paragraph 828, it's agreed that any lighting issues during the construction phase could be secured via a condition to ensure the development, while it's being built, has no undue impact on nearby residents. So you've applied your mind both to the future residents of the site and to existing local residents during the building of the site there, is that right? Right. And then next, arboriculture or trees. And then highways. You were satisfied, you've told us, with the advice from the Highways Authority.
Yes.
The inspector will have heard that local residents, will read local residents, because as you've heard, the inspector's got everything that local residents wrote in, both to the council during the application and to the inspectorate following the appeal. And as we've heard, he's going to visit the site.
And form his own view.
And form his own view, both this week and subsequently. And then the next section of the Statement of Common Ground, landscape, character and visual amenity in green wedge. We know that there's, that the green wedge is the issue. There isn't a reason for refusal dealing with, for example, harm to visual amenity, subject to a condition that will require the development to be properly landscaped and planted and all the rest of it. Again, there isn't an issue on education, because there'll be contributions if they're required, and there won't be if they're not required through the Section 106 agreement.
As is standard.
And then flood risk and drainage is agreed. There isn't an issue about that. And then, again, in Section 9, there's a list of conditions, or possible conditions, which we'll come back to in a roundtable session at the end of the inquiry, and the same in Section 10 for the draft planning obligation, the financial contributions that are going to be made. And then Section 11, matters not agreed. Relatively short section. So short that it even featured as an unusual circumstance in Mr. Young's opening submissions. And an acknowledgement of the tilted balance and the nub of the issue. At paragraph C, in the reason for refusal, the Council gives significant weight to policy CP18 green wedge. The weight to be afforded to policy CP18 and the planning balance is not therefore agreed. So having looked at all that, why is the green wedge, in your view, the harm to the green wedge in this case so great?
I mean, we've heard several contributions now that quite rightly describe the green wedge around the city as extremely important. They're the lungs of the city, the fingers of green space, separating communities, ensuring that we have quality environment across the city whilst dealing with our responsibilities to deliver housing. Derby is a very compact city, and there are challenges to providing the housing targets, and I think that always will be, and that's why we work with HMA partners to deliver housing growth via urban extensions, which we've seen via the current local plan. And that really focuses again on the importance of retaining these pockets of very important green wedge.
Yeah. And this green wedge in particular, it's sometimes said that a picture paints 1,000 words. And in the evidence, with Mrs. Ellensfield's evidence, we've got her Appendix 1, which is a plan which shows the green wedge, and we're going to borrow it with grateful thanks to Mrs. Ellensfield. Looking at that plan, her Appendix 1, first of all, we can see, can't we, a black line, the bold black line near the top of the plan, which is the administrative boundary between the city of Derby in the south and, as it says, Erewash district in the north. And in the main, to the south of that line, is the lighter green colour, which the key tells us is Greenbelt.
Sorry, can I just stop you? I'm just struggling to get the plan before me as we speak.
Ah, right. Yes, I'll give you the core document number. It's CD 11.03. And it's Appendix 1 to it.
I've got it before me now. Thank you.
Can you just hold up your version of the plan so the inspector can see that he's got the same version? Good. He's just got it in rather larger scale than we've got it, which is good. So yes, so the black boundary, the bold black boundary, up at the top of the page, Derby to the south, Erewash to the north. And then the lighter colour, I've said it's yellow, it might be, I don't know what it is, but it's lighter. That's the green belt.
Correct.
And then we've got Spondon to the east and Chadston to the west.
Yep.
And level with the top of Spondon, green belt becomes green wedge. And we can see, first of all, that to the north of West Road, about halfway down or up the green wedge on the Spondon side, is shown the school. That's the primary school. And then there's a finger of housing to the north side of West Road. And all of that is outside the green wedge. So the green wedge narrows at that point, is that right?
That's correct.
Yeah. And then to the south of West Road, although in the green wedge, are the buildings and playing fields of the school.
Correct.
And that's the secondary school.
Yes.
And those buildings are in the green wedge. Because as we'll see with later witnesses, one of the functions of the green wedge is to host schools. But so far as the gap between Spondon and Chaddesden is concerned, does the presence of the school have an effect on the perception of the gap?
It narrows it.
Right. And what about the housing to the north of West Road and the primary school? Does that have the same effect?
Absolutely, it narrows it.
Okay. And then on Mrs. Ellensfield's plan, on the parcel of land that she's marked 9, can you see the indication of 3 trees underneath it?
A little bit difficult on my smaller plan, but I believe they're there, yeah.
Yeah. The inspector will see on the ground that's a wood, yes. Unless it's been chopped down.
No,
I don't think it's still there, is it? Good. And then on the parcel of land that has been marked 10, the inspector will see that that's an open field that's part of the school premises.
Yes.
And then what's proposed by this appeal, in the parcel of land marked 2B, on the areas, roughly, nobody's going to be holding anybody to account over it, but roughly in the areas of the grey marking is where the housing is intended to be. And then in the land marked as parcel 2A, that's where the open space and the landscaping associated with this development is intended to be. And to the right of that, we know is a disused covered reservoir. Do you know much about that? No, all right. other than that's what it is, a disused covered reservoir. All right. So, if this development goes ahead, what does that do to the perception of the gap between Spondon and Chaddesden as it runs up and down the Green Wedge?
It significantly narrows it.
Okay. Now, somebody will say to you, somebody cleverer even than me, will say to you, well, it's only going to be as narrow as the housing on West Road or the secondary school buildings to the south of it. So it's not going to actually make the narrowest point any narrower.
I would say it contributes significantly to the narrowing.
Yeah. So far as the north of the Green Gap is concerned, what effect will it have on Spondon creeping closer to Chaddesden?
It does exactly that.
Yeah. And so overall, what do you say the perception is likely to be as to the state of the Green Wedge? Will it have become noticeably narrower, or will it have stayed the same in the minds of local people?
I think it's absolutely clear it would be significantly narrower.
Is it a rounding off situation that we're dealing with here? Are houses being proposed in an area that will round off anomalous bits of Green Wedge?
No.
No. Do you think it would set any form of precedent for development on that side of the Green Wedge?
Absolutely.
Now, you heard both advocates, myself and Mr. Young, say in our opening statements that Derby is going to need to grow to meet its future needs. And that both of us accept that in the future, in the next local plan, some green spaces may well be needed to be built on.
And that's a matter to be considered via the local plan process.
Okay. One of the things that if we go back to our plan, we can see where Spondon is. And if the inspector looks at other plans or even Google Maps with a satellite view on, he'll see where Spondon is. Mr. Palmer described it as a village. Was it once a village?
I think way before we were born,
Right.
hundreds of years ago, I think many places such as Spondon, Micklover and many other settlements were very small villages, but would have to go back a very long way when it was
Okay.
classed as.
They've obviously grown with time.
Absolutely, Derby has grown significantly.
Yeah, and Spondon is now what it is and where it is.
Yes.
And if we look at this plan, if somebody decides that Spondon needs to grow, Derby needs to grow, and Spondon needs to grow, and if green fields on the edge of Spondon need to be sacrificed in order to grow, to meet the housing need, what are the options at Spondon, looking at this plan?
Limited.
Okay. If somebody in the future, we're not going to do it at this inquiry, but if somebody in the future needs to choose the least worst option, and it comes down to a choice between Spondon growing northwards into the green belt or growing westwards into the green wedge, do you think that's an easy answer? Is it a foregone conclusion which would be chosen?
It wouldn't be the green wedge.
You don't think it would be the green wedge?
No.
Of course, last time Derby was plan making, we've seen that in the 2012 Green Wedge Review, which I know you've got an extract from, and for the inspectors, which you could just please turn up. And its core document CD 9.01, and on internal page 5, PDF page 6, sir, which is the introduction page, there is a figure 1.1, the location of Derby's 13 green wedges. Those of us who are looking on screens now have the luxury of being able to blow it up. And we can see that green wedges exist all around the clock face of Derby.
Yes.
What would your reaction be if somebody said, right, well, we've now got to the stage where we continue to need to bring forward local plans that last 20 years at a time, or just under 20 years at a time, and I'm sorry, but now we've got to build on all our green wedges because we've reached a stage that houses have got to take priority. Derby can't go outwards anymore, we've now just got to cover the green wedges. What would your reaction be to that?
Well, I'd say that the process of reviewing Derby's housing needs and the sites, potential sites, is going to be wrapped up in the ongoing work in the emerging local plan. And it is the duty of the local authority to consider all open spaces, whether they be green wedge or via HMA partners that are outside of the city boundary. All of that needs to be in the mix. But it's clear that we currently have a policy of CP18 which places very significance to the green wedge as adopted in our current local plan.
Yes. And were you around in 2017 when the last local plan was being adopted?
Yes.
Yeah.
I've been a councillor since 2008.
Yeah, so you would have been aware of the you've been through a cycle of plan making.
Yes.
Yeah. And are you aware that last time Derby's needs were assessed to be 16,388 dwellings in the plan period, but in the end it was agreed that only 11,000 would be met within the city?
Yes.
And that the rest would be exported to 2 local authorities, or maybe more to surrounding local authorities.
Yes, and those houses have predominantly been already delivered now or are being built out.
Yeah, I mean, I think there was a hiccup with Amber Valley's local plan, wasn't there?
Yes, primarily South Derbyshire have delivered as an HMA partner very significant housing for the city as part of the current local plan.
Yes. South of Sinfin and places like that.
Mostly west of Micklova generally. And,
of blessed memory. Is that a sort of process that you think is going to have to be repeated next time, or have you not thought about that as members yet?
So we have a working party already on the local plan, which is a cross-party working party, working positively with council officers, and that's been ongoing for some time. My understanding is that the local plan proposals will be emerging in draft fairly soon with formal consultation by the correct process later in the year.
Okay. Are you a member of that working party?
Yes.
Right, okay. So you're aware of the work that's been done?
Broadly, yes. I mean, obviously, I'm not the cabinet member with responsibility, obviously, but we're here to assist the council understand the process and help how we can.
Right. And so, do you expect that once again Derby will be looking to its neighbours?
Well, you can already see that with the South Derbyshire local plan, which is now in pre-submission phase. There's a very significant development south of Mickletover, a strategic site for predominantly, as they say, Derby needs. Potentially another strategic anchor via South Derbyshire to assist potentially with another strategic site north of Mickletover via Amber Valley, and a very significant site, for example, being proposed south of Chellaston via the South Derbyshire local plan. Okay. As I say, our local plan, Derby City plan, is in train in terms of the work that's ongoing behind the scenes and will be forthcoming soon. Okay,
so your neighbours are anticipating, are they, that in the next round of plan making, Derby City won't be able to meet all its needs within its boundaries?
I think that's already established. If you read the South Derbyshire local plan, which is now, as I say, in pre-submission, the statements in there make that clear.
Right, good. Okay. So we then come to this tilted balance, which you were told by the officers and which you've said you understand in your proof of evidence because of the situation we're in without a 5-year housing land supply. The tilted balance means that the committee, in the first instance, and now the inspector, should have grant permission unless the adverse impacts significantly and demonstrably outweigh the benefits. So the default position was you should have granted permission unless you were sure that the adverse impacts significantly outweighed the benefits. And the committee was collectively satisfied. And are you personally satisfied now you're giving evidence to the inspector?
Absolutely.
Yeah, good. Councillor Holmes, is there anything else you want to add before you stop giving your evidence in chief and Mr. Young starts asking you questions after lunch?
No, I'm fine, thank you.
Good. Thank you, sir.
Can I just ask for one point of clarification, not on what you've just responded to Mr. Richards, but I know you've appended this Acorn Way appeal decision, which you didn't touch upon then. I don't know if you could pinpoint a plan depicting where that site is precisely in the evidence.
Oh, it's the same plan we've been looking at.
Yeah. It does mirror what's in the Green Wedge review. I think it's the promoted site in there, is it?
Yes.
Okay.
We can double check the red line.
I didn't think, from looking at the evidence, I couldn't actually see a precise plan that was actually submitted as part of that application.
If you'd like one, we'll get the red line plan from that application.
That'd be useful.
Yeah. Or even the red line plan and the illustrative master plan that the inspector had.
Yeah, if the appellant's willing to.
Aha. Let's have a look at that. It's yes, bottom left-hand corner anyway. Roughly where the orange was shown in the Green Wedge review.
Yeah, that's what I thought it was.
Yeah, yeah.
Okay, that's useful for clarification. Thank you. Okay, yeah, I don't have any further questions at this point.
Thank you.
Do remember you are in Purda over the lunch break, so you can't talk to anyone else in your party.
Yes, sir.
Yes, it means you just go and have lunch by yourselves and be back, and just be back here and in that seat by the time the inspector is about to give us.
Yeah, I was going to say, well, I said at the start we'd have an hour, so I suggest we do have an hour and we kick off again at 2 p.m, please. Thank you.
We should now finish it today, shouldn't we? Yeah.
I think Helen knows it.
That's very welcome, yes. Thank you very much.
So just approach Isabella to set that in train. And yes, I've come to Mr. Young now. I've seen that you're anticipating 3 hours. Is that the case?
Yeah, I think with some re-examination will be done this afternoon, though, so the council will be free.
Good. And remember, we need to be vacated by 5 for the meeting, yeah. And it might be best, if we're obviously sitting for quite a long time, if you want to suggest to me when a natural break might be.
Yeah, absolutely. Or alternatively, if I'm getting carried away, then feel free to...
I'll remind you.
Yeah, Mr. Richards will remind me, or yourself, so yeah.
Okay. And other than the proofs, is there any other important document that I should have?
Yeah, the core strategy, which you've got in the CD documents, and also the committee report. The committee report is CD 302, and you've got the core strategy as CD 4.01.
Okay.
There may be some others, but if that sort of takes us up to the break, that'll be fine.
Okay. Thank you.
Good, thank you. Councillor, good afternoon. I wonder if you could take out the committee reports. So that's the officers' report at 3.02. Do you have that?
Yeah, I'm just finding it now.
Yeah, sorry.
Okay, which was the reference again?
And would you mind going to section 7.2, and that's on page 13.
Okay.
Thank you. So it says the green wedge impact, and it says the proposed development of major new housing, and major is 10 or more dwellings, according to the NPPF, would be located within the Chadderstone-Spondon green wedge, and for this reason the proposal is contrary to the provisions of policy CP18 of the Derby City Local Plan, Part 1. Do you see that? Mm-hmm. Good. And then it goes on to talk about the green wedge performs an important strategic function, etc., all of which we'll discuss this afternoon. And then if you go down to the next paragraph, it says the green wedge policy is still considered to be relevant and up to date and consistent with the aims of the NPPF. Do you see that?
Yes.
Yeah. And that's something you agree with, isn't it?
Clearly.
Yeah. Accordingly, weight can therefore be given to the policy. We're not told what weight, but given its consistency with national policy and has been successfully tested at previous planning appeals, the question is whether there are material considerations, okay? Now, so I'm being clear, although obviously the office has recommended approval and that's to our advantage, I'm going to put to you that in agreeing with that and what the office has written, it's plainly wrong, okay? It's wrong, and let me go through the stages of why the officers have got it wrong, okay? First of all, could you turn up the statement of common ground? Hopefully you've got that to hand. And within that, what has been very helpfully done is the policies have been listed at page 7, the relevant development plan policies. And if you look at 6.4, there's a table 1.
People could make sure their mobile phones are switched off, please.
Do you have that?
Yes.
Okay, and then if you look down, you can see the green wedge policy has got an asterisk by it. Do you see that?
Yes.
And what it says at 6.4 is the most important policies for determining the appeal denoted by an asterisk. Do you see that?
Yes.
What does that mean, the most important policies for determining the appeal. It should actually be the application. That's what the wording in the MPPF says, but we're at appeal, so I think we understand what's being said. What does that mean, the most important policies for determining the appeal?
Because it's tilted balance versus CP18.
Okay, let's take it in stages. The most important policies, what does that mean?
In terms of the actual decision, CP18.
Yeah, okay, so there's another one as well, CP6, that's the housing delivery. Do you see that?
Yes.
Okay, and what the most important policies mean is the policies that are most important for determining this appeal by Inspector Smith, yes?
The inspector will make his choice based on the evidence. Can you repeat the question?
Yeah, by all means. What it means is that CP18 is one of the most important policies for determining this appeal, yes?
Tilted balance versus CP18.
Just leave tilted balance to one side. I'm going to come to tilted balance. It's just I want to see and test your understanding of the policy.
The decision the committee made was based on CP18.
Yeah, but that's not
so
my question.
Now we're at an appeal testing that.
Yeah, I'll start again with my question. That might be easier, okay? What most important policies for determining the appeal means is that's the one of two of the most important policies the inspector needs to consider, yes?
CP18 is a very important policy.
Yeah, very important, absolutely. So if we then go to the consequences of that, what happens if you haven't got a 5-year land supply, please? What's the consequence for the most important policies?
Tilted balance.
No. Try again. I don't mean to be pejorative in that sense, but just tilted balance isn't an answer to the question. Tilted balance is just a statement. What is the consequence of not having a 5-year land supply on the most important policies for determining the appeal?
I don't understand.
Okay, and that's fine, and I understand why, but this is why we have a distinction between professional planners and councillors. You don't understand, so I want to be fair to you and explain.
No, I don't understand your line of questioning,
okay,
not
right.
necessarily the overarching.
So what is the consequence? You keep saying tilted balance.
Yeah.
I'm going to come to that, but what is the consequence of not having a 5-year land supply on the most important policies for determining the appeal?
Why is that relevant to the decision?
Don't worry about whether it's relevant, just see if you can answer the question.
I believe...
Could answer the question directly.
Yeah, so just I'll repeat it again. What is the consequence of not having a 5-year housing land supply on the most important policies for determining the appeal?
I don't understand the question.
Okay, that's fine, and I've had a couple of goes at that. If you don't understand, then you don't understand.
In the context that you're asking.
Yeah, it's fine. Look, all I need is to whether you understand what the consequence is, and you don't, and that's fine. And I know you say you don't understand the question, but that means you also don't understand the answer.
No, not necessarily.
Okay, let's try again. If you haven't got a 5-year land supply, what does the lack of a 5-year land supply mean for the most important policies for determining the appeal?
It carries weight for approval.
Okay, let's. Yeah, and I'm going to go to that. But what I am keen to know is your understanding of that. So as the inspector suggests, we've both got our MPPFs. Do you have your copy there as well?
I haven't got the full MPPF in front of me. I can
that's
pull it up
fine.
if you want to give me...
Yeah, that's absolutely fine. It's Mr. Richards is going to bring you a copy.
Thank you.
Thank you, Mr. Richards. Right, paragraph 11.
Yeah.
And it's a popular page. And if we have a look at Part D, Part C and Part D says for decision taking. Do you see that?
Yes.
And that means when the inspector's making a decision or when the committee made a decision. Do you see that?
Yeah.
Okay. And it says where there are no relevant development plan policies, well, we're not in that situation, there are relevant policies. The green wedge is obviously a relevant policy. Or the policies which are most important for determining the application are out of date. Do you see that? Mm-hmm. Now, we've agreed in the Statement of Common Ground that this is the most important, one of the most important policies. Do you see that?
Yeah.
Okay, so there's no dispute about that. And it says where the most important policies to determine the application are out of date. And then there's a footnote. Do you see that?
Yes.
Footnote 8. And what does footnote 8 tell us about what happens with the most important policies, please?
Well, you have it in front of you. Do you want me to read it, or would you like to read
It's
it?
your understanding, really.
As written.
Yeah, but what's your understanding, please?
That includes for applications involving provision for housing situations where the local planning authority cannot demonstrate a 5-year supply.
Yeah, and you can't demonstrate a 5-year land supply, can you?
Currently, no.
No. So the position is that your policies that are most important, which includes CP 18, is automatically out of date, isn't it?
I don't agree with that.
Right.
CP
So you
18 is very relevant.
Yes, okay, that's fine. You have said you don't agree with the MPPF, which is
No,
fine.
I don't. No, I did not say that.
You
did not say I did not.
You did. You
No, I
absolutely
didn't.
did.
You were saying CP18 is not relevant. I'm saying it is.
No, this is really, really important, and you'll forgive me if I just take time, and I don't want to confuse you, but I pointed out to you in very, very simple terms why CP18 must be judged out of date by the inspector. Must be. And you've said to me, no. You don't think, together with the fellow councillors that I've already asked questions on, you don't think that CP18 is out of date, do you?
CP18 is extremely relevant
No,
to this
that's not my
council's
question.
decisions.
I know what you say about the relevance. You think CP18 is not out of date?
It's an adopted policy that we can rely on.
Again, I'm going to
protect
try
green
one more
wage.
time, Councillor. Focus on the words if you can. I don't wish to be rude, but it's really important I get answers to my questions. Qualify it in any way you wish. But you don't accept, do you, that CP18 is out of date?
In my statement in 2.5, it explains what the situation is, I believe, in CP18.
So you believe CP18?
No, if you look at my statement, summary of proof of evidence,
Yep.
2.5 explains it.
Yes, and I'm just asking you to tell the inspector in the inquiry in very clear terms, do you think CP18 is out of date?
It's relevant when we're making the decision in the planning committee, taking into account the MPPF. CP18 is absolutely relevant to the decision.
Nobody's questioning whether you think it's relevant or not. What we're asking you is a question. This is the 7th time I've asked. Do you think CP18 is out of date?
All policies will need to be updated in the local plan, which is going to be emerging. If CP18 is updated, re-adopted in some other form, and that be the case.
Councillor, I'm here all afternoon. We can do this like Jeremy Paxman, if you wish. I'm just going to keep doing the question until you give me an answer, and it's a yes or no. Do you think CP18 is out of date?
I don't think that's a relevant yes or no answer.
There is a yes or no answer. You can qualify as a lister. You can qualify your answer afterwards, but you can yes or no.
Is CP18 out of date, yes or no?
I don't think so.
No, you don't, no. Which is you arguing against national policy, isn't it?
It's taken into account national policy, and CP18 carries significant weight when also taking into account MPPF and national policy.
Your position at this inquiry and the position of your fellow councillors, because I asked it, is that it's not out of date, which puts you in direct conflict with national policy. So what you're saying is fundamentally wrong, councillor, isn't it?
No. In my statement of case, it makes it clear that we take MPPF in due consideration. However, CP18 is something that we decided was the most relevant thing to actually make the decision that we made, and it carries significant weight.
Yes,
we think that the previous inspector validated CP18 and it's still relevant.
Yeah, it's fine. I don't mind what your answer is. I just need clarity about it.
And I think I've given it.
And then obviously the consequences of you saying that. But I have to put to you, and I have put to you, that you are simply misunderstanding national policy. You don't understand national policy at all, do you?
I think that's extremely unfair to say that.
No, but I've just put to you in really simple terms, I hope, step by step, why it's out of date. It's automatically out of date as a most important policy because you haven't got a 5-year land supply, and you won't accept and you are arguing against national policy, aren't you?
I will have to agree to disagree, because this is about agreeing to build on our green wedge, and CP18 is extremely relevant in that case.
So, yeah, nobody is doubting that CP18 is relevant, because obviously we've accepted, as has the council, that it's one of just two of the most important policies for determining this appeal. Can we go then, please, to the core strategy and to have a look at CP18 itself?
Okay.
Yeah, I don't spend time dealing with footnotes 7, because Mr. Richards will correct me if I'm wrong, but the statement of common ground, the council are not claiming it's one of the policies in the framework that protects assets. Yeah. Good. Okay, so green wedges, this is the policy. The council will continue to identify green wedges, and there's then a whole series of subsections to this policy. So we've got A through to K. Do you see that?
Yes.
And then as far as K is concerned, it says seek to ensure that where urban extensions occur, the principle of the green wedge itself will continue. Do you see that?
Yes.
So it's not ruling out the possibility of development in a green wedge. The test is whether the green wedge itself will continue, yes?
Yes.
Which means, will there be a wedge, basically?
I mean, it's interesting you raise this, because in previous questioning, you've suggested that the local plan is completely irrelevant, that we've adopted and runs till 2028. This clearly shows that it is currently running, has CP18 in it, and the forthcoming local plan will reconsider green wedge along with all the other aspects.
Okay. I'm not going to ask you anything about the local plan, because it's got no weight and we've no idea whether you'll ever do it. So I'm not going to ask you about that.
Sorry, sir, can I just interject on that point, because it's a very important point I need to make about the local plan. Okay, no problem.
Okay. I'm just focusing on the adopted plan and what it says, and the point that I put to you. So your answer there, just let me just go through, unpack that a little bit. We don't say the core strategy in the local plan is irrelevant. That would lead the inspector into legal error. That led to a Supreme Court case the last time a judge thought that was the case. It's not that the plan is irrelevant, it's about whether it's out of date, and then the weight that can be given to it. You understand the distinction?
Yes, sorry.
Yeah.
I'll clarify that you suggested that rather than it being completely irrelevant.
Yeah, because we're not saying, and that's why I'm going to the policy. But just back to this point, seek to ensure that where urban extensions occur, so as a matter of logic and as a matter of English, the policy itself anticipates that urban extensions can occur in green wedge locations, doesn't it?
A local plan will consider that when it's adopted.
Reference to the adopted policy, I think.
Yeah, this is a local plan as adopted.
Yeah. I understand what you're saying, but it's not that it's a local plan issue. We're now applying a policy. The local plan has happened. The policy is here, and Part K admits of the possibility of urban extensions in the green wedge, doesn't it?
But the council has very well
Just
defined...
not a but, because that's not an answer.
Let me finish, please, will you?
No. The way this works, councillor, and I'll be corrected if I'm wrong, is you must answer my question, but you can also add it. But just let me finish. But isn't an answer to a question. But is starting an argument or having your qualification without answering it. So
can I just build on that clarification? So yeah, if you could try and start, it may not be possible in some circumstances, but as a starting point, a yes or a no, and then qualify however you feel necessary.
Yeah, I'm not stopping you from saying what you want to say, but equally, as the inspector's pointed out, I'm entitled to an answer to my question. So, Part K admits to the possibility of urban extensions occurring in a green wedge, doesn't it?
Yes, but I'd like to qualify that with...
Yeah, but by all means.
Okay, so it also defines clear green wedge areas across the city, which we've already dealt with this morning, and the CP18 clearly defines those areas as being the green lungs of the city that we want to protect. It clearly defines what should be allowed to be built there, and it is not housing. So, contrary to what you've just said, I think the balance should also be that a recognition of how important green wedge is for this city.
All of which I understand, but you see, where it says where urban extensions occur in the context of that policy, the test isn't, are you going to build on a green wedge, as if it's somehow, more protective than green belt, which has got caveats as well, like very special circumstances, which I'm sure you're aware of. What it's saying is, if there's going to be an urban extension, it's the principle of the green wedge that should continue. So there needs to be a green wedge that continues to exist, yes?
Obviously, yes.
Yeah, good, okay. And then if we go down to the reason justification, so that's the text supporting the policy, and we look at 5.18.6, it says to prepare the Part 1 plan. Are you there, Councillor?
Yes.
To prepare the Part 1 plan, the Council carried out an extensive review of green wedge boundaries to help identify strategic housing sites. The Part 2 plan will consider further amendments to green wedge boundaries as part of the process of identifying non-strategic housing and employment sites. Do you see that?
Yeah.
Okay, so the Part 2 plan was meant to engage in a further review of the green wedge and its boundaries, wasn't it?
That would be the intention, yes.
Yeah, but it was never done.
No,
and the inspector was told it would be done by December 2017, and that was over 7 years ago, wasn't it?
Clearly.
Yeah, okay. So we know, don't we, that there is anticipated to be further amendments to the green wedge for non-strategic housing sites, yes?
Well, that's to be determined via the local plan process.
But that would suggest to me probably quite a likely reason why you didn't produce a Part 2 plan, because actually the councillors didn't want to grapple with that issue and identify further green wedge releases.
I don't think there's any evidence of that.
I'm just wondering why you didn't do the plan. What's your reason for why this council... What is your reason for why this council told a planning inspector we'd produce it by December 2017, and then for 7 years they didn't? What's your understanding of why the council failed so spectacularly to do that?
I don't think this council's any different to many others in that respect. My personal opinion is that successive governments have changed national planning policy. For example, there was at one time a very significant white paper that emerged and then wasn't adopted via Parliament. So there was a lot of uncertainty, and I think it's fair to say, in my opinion, that this local authority and many others struggled to grapple with that to form cohesive policies. So in some cases that would lead to delay and certain policies not being brought forward because of that uncertainty.
Okay. You're right, there were lots of other councils that were equally reticent to actually do their job and produce a development plan as a development plan making authority. But others did. So given that others did, it's no good saying, well, we're in with others who didn't. Why didn't you do one when you knew you were meant to have an up-to-date plan? And in particular, I suppose, why did the council tell the core strategy inspector that it would be done by December 2017? Do you know why?
But that would be a question for the relevant cabinet member and or lead officers who actually said that.
Yeah, but I unfortunately, I've asked everybody, and I can't be criticised, everybody who's a councillor who's come forward, I've asked questions of. I don't have anybody else to ask. You are the council's witness. You must have asked your colleagues and the head of planning, why didn't we do a plan when we promised to do one by December 2017? You must have asked that question.
I think I've answered that in a previous reply very recently.
You can see the difficulty, can't you? Here we are with a non-strategic site. This isn't hundreds and thousands of houses. This is 90 houses. It's a non-strategic site. And my clients might have expected a Part 2 plan, mightn't they? Given the council told the planning inspector that they would, my clients might legitimately have expected that to happen, mightn't they?
They may have done, but they brought the application under those circumstances.
Yeah, but they waited and waited for their site in the Green Wedge, and they waited for the non-strategic plan to allocate additional sites where green wedge boundaries would be considered as part of that process, and it never happened, did it?
No, but we have a green wedge review in 2012. We have the current local plan which was adopted. The green wedge is clearly defined. So applicants can see that as evidence as to what the city's proposals are in terms of green wedge and its currently adopted policies. This particular green wedge in this application would significantly narrow a very important, all of them are important, but this one, this proposal would significantly narrow and have severe impact on this particular green wedge.
I understand your case, all of which we're going to come to, but that wasn't my question. What was my question?
Your question is challenge on why the local Part 2 wasn't adopted.
Yeah, it was my clients had a legitimate expectation to wait a local plan Part 2, which would review the greenbelt boundaries for non-strategic sites. We've agreed that never happened. You then said, well, we've had a greenbelt review in 2012. How does the greenbelt in 2012 help with the promise of a greenbelt review by 2017? How does that help?
Well, we work with our HMA partners with regards to the local plan to provide... Sorry?
My fault, I've been corrected quite rightly. I said belt and it's wedge, green wedge. I'm sorry.
We work with HMA partners to deliver our housing requirements based on the currently adopted local plan. And the council has been working very proactively to do that. We haven't delivered as many as we need to, we know that, but that's, again, not uncommon for local authorities. So the framework that you are suggesting, I believe there's enough evidence there in terms of the core strategy green wedge review and the current local plan, which runs till 2028, to offer, and CP18, importantly, to offer that guidance for applicants.
But Councillor, I don't understand your answer, because here was the promise of a Part 2 plan identifying non-strategic housing and employment sites and considering further amendments to the green wedge, all of which was promised to the local plan inspector, none of which has happened. So you haven't done what you told the inspector, the planning inspector, you would do, have you?
And I've explained the
answer is no, we haven't done it.
In terms of the challenges of national policy, then that was my answer.
I'm going to come to that. But you haven't done what you said you'd do.
Well, clearly, we haven't adopted a local plan Part 2, no.
No, okay. Now, just about this, other councils are equally as...
not equally, some councils.
Some councils, yeah. So, because first of all, it's not all councils, and we dealt with that point. But let's deal with this. It's no defence to a lack of a 5-year land supply to say to the inspector, well, we're not the only ones. Other councils haven't got a 5-year land supply. That's no defence to that, is it?
No, and I'm not saying that is a defence. I'm just making a comment.
Yeah, you've got
adding context.
Yeah, you've got to deal with your own problems and face up to them, haven't you?
Absolutely, and that's what we're going to be doing via the emerging local plan, which work is ongoing right now.
And
Regulation 18 in the autumn.
And you're going to, even though you didn't produce the plan you told the last local plan inspector to produce, we're now to believe that you will produce this one.
Well, I know for a fact, because I'm part of a working party that for several months has been working with officers on the emerging local plan. It's fairly well advanced and that work is ongoing. I'm not speaking as the cabinet member who leads on these things, but I understand that there'll be public consultation regulation 18 this year. So I don't agree with your statement that there's no confidence that it will be delivered.
Okay,
that will mean that we have full review, which is where it should be, not an appeal, in terms of considering how we move forward in terms of our green wedge.
You do understand that people's actions and their failure to do things will inevitably affect their credibility?
Can you explain what you mean by that?
So if you promise to do a plan and you don't, that affects your credibility, doesn't it?
Somewhat.
Yeah, somewhat. So you know as well that an emerging local plan can't be given any significant weight if there are outstanding objections, or a policy can't be given significant weight if there are outstanding objections, yes?
Yes, but I'd like to make the point that I think it's entirely incorrect for you to suggest that this council isn't pursuing the next local plan, isn't carrying out significant work, because I know that is the case. And I also like to make the point that we're always going to be in a position where we're at the tail end of an adopted local plan and working on the next one, which is the case here, 2028, the current local plan runs to. So this is the process.
Yes, but the inspector may be very interested in what you're planning to do. He may also take the view, well, where has that got to? And the point is that we've agreed that if there are outstanding objections, it can't be given significant weight. We haven't yet reached the point at which the plan has been submitted to the Secretary of State, have we?
Clearly not.
No.
I understand that that's going to be, Regulation 18 will be in the autumn, I believe, and then obviously within a few months after the statutory consultation, it will be pre-submission, and that's the period that you're talking about, which would probably, I would expect, be a few months into next year. Yeah,
so if we haven't had it submitted to the Secretary of State, we know that obviously there hasn't been an independent examination by a planning inspector. That's right, isn't it?
Well, clearly not, because we haven't published the draft local plan as yet.
Yeah, and we don't know whether the plan will be adopted, because there are plenty of councils, or there are some councils, that get the inspector's report and then they abandon the plan. We don't know whether you're going to do that, do we?
Well, Amber Valley had difficulties in that respect. I don't perceive there to be that issue for Derby City Council. I have every confidence in officers, the cabinet member and the councillor cohort to ensure that it's a very robust local plan which will be fit for adoption. Yeah,
we haven't reached Regulation 19 stage, have we?
No, I've just explained that Regulation 18 will be later in this year, followed by Regulation 19.
Yeah, and what you're going to do is do a new style local plan, because you haven't submitted by the 19th of March, so you'll be following the new planning system, yes?
Yes, the changes the government made will be relevant, yes.
Yeah, but we don't have the guidance or the procedure for the new local plan system yet, do we?
It's emerging, but does that mean we shouldn't be working on it?
No, I'm just asking you, we don't even have the basic guidance or structure of it.
I don't agree with your assertion that this will somehow slow our process down.
Well, the new plans are going to have a lot less by way of replicating the MPPF. That's because there's going to be national development management policies. We haven't seen any of those yet either, have we?
Is that the fault of the local authority?
No, I'm just saying, in thinking about when your plan might take place, it's a new style plan, we've agreed that. We haven't got any of the regulations or any of the detail about what these new plans will be like. We know that they won't replicate national development management policies. We haven't got those yet. They presumably come first. So, in reality, you say, well, we're going to submit in the autumn.
Sorry, sir. Sorry. Just to clarify, I didn't say that. I said that public consultations expected Regulation 18 this autumn. Regulation 19 pre-submission will be later than that. Okay, but the Regulation 18 version will be a version of the plan with policies and allocations in it, won't it? It will have, obviously, the draft local plan. Yeah, it's fanciful to imagine that's going to be submitted in Regulation 18 version in the autumn, because we don't even know what that new style of plan is going to look like, because we don't have the regulations and we don't have the detail. I think that's supposition. I think that we have every intention of developing the local plan to be put to the public in consultation in the due process by the end of the year. So we don't have a Regulation 19 or a Regulation 18 version. So where do I go for the purpose of this inquiry to see the detail of this emerging new plan? Where do I go to? Which document is it? Well, I think it's relevant to tell you that the council is working hard on that, because in my opinion is that you were asserting that the council wasn't, and suggesting that it was fantasy that the council could provide a local plan, and there was huge uncertainty. I don't agree with that. Fanciful. Well, I don't agree with that. I think my experience of working on the local plan in terms of a working party and what officers have presented to us so far is that it's moving forward in due course. Okay. So, and really, I'd like to say that this is about the decision that was made by the planning committee, which was based on CP18. Now, Councillor, can I just ask you, can you remember what my question was? Yes, it's about confidence in bringing forward a local plan and having Regulation 18 ready in line with national policy.
Councillor, that wasn't my question. Would you like me to repeat the question?
If you like.
Yeah. Where is the document I can go to that tells me about any of the detail about your emerging local plan? Where is the document?
It's an emerging local plan. There isn't a document that's put in the public domain as far as I'm aware.
So you will appreciate, from the inspector's point of view, applying recognised policy, that he can't give significant weight if there are outstanding objections. But we don't have any outstanding objections because there haven't been any opportunities to make any objections, because we don't have any form of plan, and in fact there is no document of any kind. So he can give it no weight at this stage, can he?
I'm not quite sure whether I completely agree with that. I would say that the decision as to whether any of our green wedge should be offered up for housing, and I'm not saying that it should be via the local plan process, not this appeal.
I understand
that's my statement, and that work is ongoing.
Yeah, but that's not the question. The question is, I've said to you that the inspector can give the emerging local plan, regardless of the complete failure to do what you said you'd do in 2017, but leaving that to one side, the inspector can give it no weight because we haven't even got a document yet. Are you saying the inspector should give significant weight to the emerging local plan?
No, what I'm saying is, I think we're dancing around wider issues here. This is about the decision that was made by the planning committee based on CP18, which is a very relevant adopted local policy.
Yeah, which is quite obviously completely out of date according to national policy. But leaving that to one side, my question to you is, what weight then? And not significant weight, which you've rightly rejected, not no weight. What weight does the inspector give to the document none of us have ever seen?
I don't think that's relevant to the inspector's
But
decision.
try and tell me what weight.
Well, this appeal is challenging the decision made by the planning committee, which clearly based its decision on CP18. So,
Councillor, you're not telling me anything I haven't heard you say before, and I understand why you say it, but that's fine. I would like assistance with my question, unless the inspector tells me it's irrelevant. What weight can the inspector give to the emerging local plan, given it's a document that nobody's ever seen?
he would have to give weight to the current local plan, which runs to 2028.
The emerging...
questions about the emerging local plan, if you can address that specifically.
So if the inspector would like to ask officers to relay whatever reports they have, whatever documents they have on the emerging local plan, I'm sure they would pass them on if it's relevant. But there's nothing in the public domain now or submitted in terms of this appeal regarding the emerging local plan.
Yeah, and so please accept with me, the inspector can give it no weight.
Well, that's for the inspector to
No,
make a
I'm
decision.
asking your opinion. No, you have to answer my questions. That's just how it works.
Well, that's your opinion.
No, it's not my opinion. I'm putting to you what your opinion is, because you are here as the planning witness for the council to defend this decision in front of the inspector appointed by the Secretary of State. And I'm asking you what weight, because you keep referring to it, do we give the emerging plan that nobody has ever seen? The answer is no weight, and that is right, isn't it?
You're wrong in suffice to say that nobody has ever seen. Well, that's not correct.
The public has never seen it.
Such is the process. The public will see it.
Well,
what I will say is, as I've said several times, the local plan is the place to review Green Wedge.
Councillor, you're not even beginning to answer the question. Okay, so I've been tolerant, and you can say whatever you like, but please give me an answer to my question. What weight do you say the inspector should give to the emerging local plan that no member of the public has ever seen?
He should give weight to a process that will review the Green Wedge as to whether they should be protected or whether they should be built on.
What weight should he give the emerging local plan? You said not significant, you rejected no weight, so you're suggesting moderate weight.
I expect the inspector to recognise that the correct process for review of the green wedge is the local plan.
I don't think you need to lecture the inspector. I don't think you need to lecture the inspector on what he needs to do, okay? Because he's a professional planner. Don't lecture any of us, please, on what they need to do. Councillor, just give us the weight to give the emerging local plan.
I've given you my answer. I'm not being disrespectful for anybody.
So I don't think you've clearly specified an answer, like direct to the question that's been asked.
Clearly, the inspector can't carry weight on a document that hasn't been adopted.
Okay, good, thank you. Well, I think that's the answer from what I've just heard. Okay, good. So the position then is that we don't have this Part 2 plan. We don't have the review of the green wedge boundaries. We also know that your core strategy is based on a housing requirement figure which is inconsistent with the current standard method figure, yes?
Yes, the government changed it in December 2024.
Yeah, under the previous Conservative administration, the numbers were higher for the 20 biggest cities. Was Derby one of those with the 35% uplift?
Yes, the numbers have come down.
Yeah, so it was over 1,000, I think 1,200, and it's come down to 900 and something, yes?
Yeah.
Yeah. So what's happened is there's been a reduction in Derby's numbers, but we've had an increase for the South Derbyshire and Amber Valley figures, which are the adjoining authorities, and actually, from a table helpfully set out in Mr. Lee's evidence, they broadly get the same overall total. Now, the consequence is that the local plan is predicated on a number, I think, of 626.
Approximately.
Yeah, and that's very helpful. So, and the new figure is 900. So what we've got is a shortfall of about 300 homes.
Well, you're comparing a requirement with a need.
Yes.
So you're comparing apples and pears.
We are, but we don't want we don't want an answer that's wrong about your housing requirement, because your emerging plan hasn't happened, so you can't claim any other figure. Your 5-year land supply is calculated on the standard method figure. I don't think Mr. Richards is demurring from that. No. So let's work on the figure you're meant to be using for now. The figure you're meant to be using for now is around 300 homes a year short of, the local plan is 300 homes a year short.
Yes, we're a very compact city. That's why we have to work with our HMA partners to actually deliver Derby's need partially.
Yeah, Mr. Richards is absolutely right. If you produce a local plan, and if it happens under the current policy, then you will be able to make your case that you can't meet your housing need, yes?
Well, the local plan process would obviously work towards delivering Derby's need.
Yeah, but it may be, and we don't know, it may be the local plan inspector says, well, look, we've got a national target of 1.5 million homes to be delivered over the course of this Parliament. That means everybody needs to pull on the rope, and Derby, you should be meeting your housing needs. We don't know what the outcome is, do we?
Well, you don't have a crystal ball, and nor do I.
That's a perfectly fair answer, I don't. And so, as a consequence of which, it may be that you have to meet 900 plus houses a year. Equally, it may be that some of the housing in your emerging local plan is transferred to South Derbyshire and Amber Valley, yes?
Well, it already has. South Derbyshire, under the previous MPPF, because they started their local plan process late last year, and are in regulation, it's pre-submission.
Yeah.
As I've said, in my earlier contributions or answers, South Derbyshire District Council are proposing a strategic site south of Mickleover, predominantly meets Derby's needs.
Yeah.
There is an additional site north of, well, they say south of Mackworth, but it's actually geographically north of Mickleover, circa 250, as an anchor potentially for Amber Valley to deliver a strategic site there. And there's another strategic site south of Chellaston. So that's just 3 examples of a very large amount of housing which will be delivered via HMA partners, partially, if not significantly, providing for Derby's need.
Absolutely.
And that duty to cooperate obviously is part of the will be part of the emerging local plan process. It would be, you'd need a crystal ball to suggest that Derby won't meet its needs. That is something which obviously Derby have been tasked to do, and I've got every confidence that the local plan process will deliver that.
Yeah, and if you can't meet your needs, then you go knocking at the door of South Derbyshire or Amber Valley, and you say, can you take some of our needs? And historically, that's what's happened, hasn't it?
Well, I don't think that's in debate, because that has been the subject of the HMA and
it's
duty
not
to
in
cooperate
debate. I'm just
for
asking
many,
you to
for
say
many
yes.
years. Well, I'm just explaining that is the case.
Yeah, so that being the case, you might expect the neighbours to take some of the housing. The difficulty, though, is that both Amber Valley and South Derbyshire have now got much higher figures because of the recalculation of the standard method under the new government, and as a consequence of which, we have no idea whether they'll take any of your housing need, do we?
Well, I think I need to correct you there, because South Derbyshire is under the previous NPPF, therefore their housing numbers haven't changed, Amber Valley's have.
Yeah, but the difficulty with that is they'll have to go to examination, they'll have to convince the inspector about the whole process, and if they fail, they transfer to a new plan. Alternatively, if they only meet 80% of their new figure, or if they don't meet 80%, I should say, then they'll have to have a review. There's lots of things that might happen, but at this point in time, we don't know how much of your unmet need, if any, those authorities will take. We just don't know, do we?
No, I disagree, because I think South Derbyshire will be very clear of what their proposal is in terms of the local plan. If you have a crystal ball, then lend it to me and let's have a look, because you're talking about things that may or may not happen.
Yeah, I couldn't agree with you more, which is the same with your plan. We don't know whether your plan will be found sound, whether the inspector will say you've got too little housing, whether your approach to housing addresses affordable housing needs, for example, and how much the other authorities will ultimately take or need to take under the duty to cooperate. The duty to cooperate is an iterative process. It's an ongoing obligation, isn't it?
Obviously, yes.
Yeah, and so if Derby identifies how much it can't meet through its local plan when it's published, South Derbyshire will have to engage in that issue, won't it?
Well, you're talking about a glass half full scenario, because I would say that the local plan process will be robust. Derby's need has gone down. I say there's a high confidence that we can work towards ensuring that we deliver on our responsibilities for housing supply.
You'll forgive us if we've got no high confidence. I appreciate you're a politician, and I appreciate why you're saying that. But, you know, did the local plan inspector have high confidence, as you put it, that you'd produce a Part 2 plan?
Well, I think we'll have to agree to disagree, because I have every confidence in the quality and the work of the officers of this council, who work very hard. In the working party that I've been part of, there is extensive work to ensure that all options are on the table, which is part of the local plan process.
I understand that.
So, you know, I don't agree that your assumption that it will not meet the supply of housing, or we'd have to go back to our HMA partners, that's unforeseeable.
Yeah, I'll put it to you straight, because it'll appear in closing submissions. My clients and many objectors observers have absolutely no confidence that Derby City Council will ever produce an up-to-date local plan. They've got no confidence in you at all.
Well, I disagree.
And that's based on your past track record of telling planning inspectors one thing and then doing the exact opposite.
I disagree. I think the local plan is a very important process, and I have every confidence that it will deliver for the city.
Yeah, and I understand as a politician, why would you say anything else? You're not going to say to me, yes, Mr. Young, you're right, we're probably going to do nothing, just play a long game until the next election, and it may be these standard method figures are abandoned under a change of government. You're never going to say that to me, are you?
Well, I just completely disagree with what you've just said. I think that's quite insulting, actually.
Well, no, I'm simply saying what you wouldn't say, not what you would say.
Well, you were suggesting that may be my opinion.
No, I'm saying you wouldn't say that. I'm not saying that's your opinion. All I'm doing is saying, obviously, as a politician, you're talking positively about your officers, about the plan-making process. But my point is, you've got to judge your comments now against your track record. And that's not an unfair thing to do, is it? We are entitled to judge you on your track record as a council.
quite clearly, but I think we've agreed that I wouldn't say that, and I'm glad that you've made that clear.
Yeah, as a politician, there's things you would say and there's things you wouldn't say. And in terms of the Part 2 plan and the review of the Greenbelt boundaries, we've dealt with that issue. What we then need to think about is if the inspector recognises properly that the policy is out of date, he needs to think about what the relationship between the green wedge is and housing. And if I take up your proof of evidence, one of the things that you helpfully indicate at 4.9 on page 7 is you say, as part of the preparation of the DCLP1, so that's the Derby City Local Plan Part 1, the core strategy, is that right?
Yes, yeah.
Yeah. The housing requirements for the city were to be delivered as part of balanced growth, and together with peripheral urban extensions, this involved reducing the scale of certain green wedge sites, yes?
Yes.
So there is a direct correlation in this city, admitted to by you at 4.9, between housing needs and the green wedge. The two have a symbiotic relationship, don't they?
Well, yes, but we carried out a green wedge review in October 2012.
Yes.
You know, that process will continue.
All of which I understand, but the inspector needs to understand that there is a direct correlation, isn't there, between the green wedge and its extent and the housing requirements for the city. There's a direct relationship which you make clear at 4.9 in the third line.
Yeah, green wedge will always be in the mix, if you like, as part of the local plan process. Yeah,
that's very fairly put. So when we come to the conclusion the council hasn't got the right housing figure and the 5-year land supply is calculated on the standard method figure, and that remains the figure until and when the council produces a plan, then each year it's 300 homes short of what it should be from the local plan, but we calculate 5-year land supply on the standard method figure until that new local plan arrives, don't we?
Yes.
Yeah, and on that basis, we know you've got a shortfall in your 5-year land supply, and that shortfall is actually below 4 years, yes?
Yes.
The previous government introduced the idea, or Mr. Gove introduced the idea of having a 4-year supply if you'd reached the Regulation 18 stage, but the new government got rid of that, didn't they?
Yeah, we're under, obviously, the current government's MPPF guidelines.
Yeah, the 5-year supply, designed to help us get to the 1.5 million, and in that respect, then, this is a council with a housing deficit, yes, a housing shortfall.
Which is not uncommon.
Yeah, not uncommon, and completely and utterly contrary to policy.
I would say it's a challenge that we're trying to meet.
Is it contrary to policy not to have a 5-year land supply?
NPPF, yes.
Yeah, it's contrary to policy.
It could be tested by the NPPF.
Yeah, it's contrary to the democratically elected national government's policy to have a 5-year land supply. You're meant to have a 5-year land supply all of the time, aren't you?
But that doesn't necessarily justify building on.
You're meant to have a 5-year land supply all of the time. That's right, isn't it?
Ideally, yes.
Not ideally, that's what you're meant to have.
We haven't got one, so,
No, and you are therefore in a position of having a shortfall, and not with a 4 at the start, but a 3, and so what we've got is a significant shortfall, haven't we?
Our shortfall is identified, it's accepted.
Yeah, it's chronic. Your shortfall is chronic.
I wouldn't say it's chronic.
No, I know you wouldn't, but I'm just putting to you that it is. It's chronic, and as a consequence of which, there needs to be solutions. Yes?
There does, but it doesn't mean that the justification would be to build on our green wedge.
Yeah, there's a Supreme Court case about this issue, but I'm not going to ask you about the law. That's not appropriate, in my opinion. It's a matter for legal submissions. But what we do know is there's this shortfall, and we know that the green wedge is intimately and inextricably linked with a symbiotic relationship to the green wedge. And we know there should have been a review of the green wedge, but it didn't take place. And then it becomes a question of saying, well, the review didn't happen, you haven't got a 5-year land supply, the policy's out of date, etc., etc. Not every parcel of green wedge land will be appropriate for development, will it?
That's something which the local plan process will identify.
Yeah, I know that, but what's the answer to my question?
Can you just rephrase?
Yeah, by all means, not every parcel of land in the Green Wedge will be suitable for development, will it?
Well, in the context of the current stance that the council has, based on the decision we made in committee, CP18 would be given significant weight on any proposal in the current Green Wedge.
Answering Mr. Young's question and perhaps try again.
Yeah, shall I repeat the question? Yeah. Even though it's out of date, even though you didn't do the review you say you're going to do, even though there's no fibre land supply, etc., it doesn't mean automatically that every parcel of Green Wedge land should be used for development, does it?
No.
No. It's a simple question then of saying, well, given all of that, given the Green Wedge is out of date, I know you don't accept that, but just assume that to be the case, then which parcels might be suitable? That's a legitimate question, yes?
Yeah, but that's to be determined via a proper process.
Yes, absolutely. The Part 2 plan from 2000, adopted in 2017, but would have been the appropriate process, wouldn't it?
No, I don't believe this appeal it should determine that. It should be the emerging local plan that will properly consider the Green Wedge as to whether any or none or all or whatever the situation may be could be used for housing.
You've just advocated for the local plan process to determine the issue. So that the local plan process that you promised the core strategy inspector was the Part 2 plan, wasn't it? That's the plan-led approach that you should have followed.
Well, I'll repeat again, the work is ongoing to produce a local plan at Derby City, which is going to fully review the Green Wedge.
Yeah, 7 years late. It's 7 years late. That review of the Green Wedge boundaries is 7 years late already.
Our current local plan with the adopted policy CP18, a core strategy Green Wedge review, that's all irrelevant until 2028.
Yeah, the Part 2 review of the Green Belt Wedge is 7 years late.
I think we've established that point.
Yeah, good. Okay. So we go back to the point about suitable sites. We've agreed that, not every site is suitable. What we might then look for are, suitable sites within the Green Wedge that would be appropriate. Now, what's very, very unusual about this site is there is built development in all four directions. I'm going to suggest that's pretty much unique. First of all, we've got residential development, the existing residential development built on green fields, probably in the 1960s or 70s. That's immediately to the east, isn't it?
Yes.
Yeah. To the south, we've got the primary school, and the secondary school is further south, but immediately to the south there's the primary school. Then to the north, we've got a Stalinist-type concrete structure, which is a water tower, yes?
Well, some people would say it's brutalist architecture and actually like it.
Yes, that's a perfectly fair answer, and I'll give you that completely. It is brutalist. There's no question about that. Whether that's Stalin style is another matter. Brutalist I can live with, okay? And then, very, very unusually, on the eastern side of the remaining wedge, or on the western side of our site, what we've got is a whole series of buildings which are on the western boundary of the site, yes?
Yes, the two communities.
Yeah, and on the... No, not the wedge, the site. So
my point is the wedge is in between two communities.
Absolutely, but I don't think, and I'm trying to be fair, I don't think you're treating the farm and the farm buildings and the sheds and the other residential properties there, I don't think you're treating that as a community. What you mean is the Cherry Hill tree area, yes?
What I'm saying is that, and
Tree Hill.
I think Councillor Smale put it well, this green wedge separates Chaddeston and Spondon.
I understand that, but I'm talking about the western boundary of the site, okay? To the west of our site, very, very unusually, for the outer edge of a greenfield site, we have got a whole series of farm buildings. There's a field in between, but we haven't gone right up to that area. There is a whole series of buildings, aren't there?
Well, yes, but we're still talking about the green wedge.
Oh yeah, and I don't doubt that. And those buildings. So I'm going to suggest to you that the council has not suggested any other area of green wedge that is more suitable for development at this inquiry than our site, have they? They haven't done that.
Well, this inquiry is about this green wedge.
But you haven't, just to confirm me, you haven't suggested any other area of green wedge that's more suitable?
In terms of this inquiry?
Yeah.
Well, why would we?
Because you might want to make a case that says, okay, we accept we haven't got a 5-year land supply, we accept we didn't do the Green Belt Review, we accept the policy's out of date, but there are better candidate sites. But you've not offered the inspector any other candidate site, have you?
I would think that's highly unlikely to expect.
Okay, but that's fine. And as a consequence of which, I'm putting to you, we have a truly unique green wedge site with built development in all 4 directions.
I think you're downplaying the importance of this green wedge.
That's not my question. I'm not downplaying anything
Well,
at this point. I'm just asking you.
No, I disagree.
This is a wholly unique or truly exceptional position as far as the green wedge in Derby is concerned, because we've got built development in all 4 directions.
That is allowed within green wedge, such as farming, parks, sports fields, and all the other things that are defined in a CP18 policy.
Yeah,
but that's not uncommon, and this is one of many green wedges with unique features. Which
you haven't pointed me to any other site which has this.
Why would I, when the decision that's being challenged is this green wedge?
Yeah, because there is no better site. There is no better site in the entire Derby green wedge area in terms of having built development in all 4 directions. There is no better site.
So if I was to make this point, and it is answering your question, you are challenging the decision of the planning committee, which was specifically asked to make a decision on this green wedge.
Yeah.
It would not have been in the remit or right for that decision to be made based on another site which may be more suitable.
Yes, I don't in any way suggest that that isn't a legitimate answer, but my case to the inspector on behalf of my client is a really, really simple one. It isn't that the whole green wedge is up for grabs. Mr. Richards has already raised, not in the reason for refusal, but he's already raised the issue of precedent in his opening. But the inspector doesn't need to worry about precedent because there's nowhere else like this in the green wedge, nowhere else more suitable because there's built development in all 4 directions. And you've got nothing to contest that, have you?
I would say that when you talk about build development, it's not housing. And I think what you're trying to do, in my opinion, is to reduce the importance of this green wedge. And I don't agree with that.
Yeah. Okay, well, that's a key part of our case, and of course, another part of what I'm going to suggest to you, there's also a lot of sort of horsiculture, as it's called, or horses and horse activity on the site. I would suggest to you that this is best characterised as built countryside. And what I mean by that is there's deep countryside, which is countryside well separated from urban areas and urban activity. This site is very much an area of developed countryside, isn't it?
No, I disagree. I think, again, you're downplaying the importance of this particular green wedge. Everyone who's spoken and you've asked questions of has clearly stated the importance in terms of the buffer between two communities.
Okay.
A local green wedge review doubled down on that. CP18 also makes it very clear as to why we want to protect our green wedge and the purpose of them. I would put it to you that your line of questioning is to reduce the importance of this green wedge, and I don't agree.
Yeah. Okay. Now, in terms of the proposals, if you could just take out any drawing you wish, which is just showing the layout of the proposal.
Caught up with 8.08 is the master plan.
That'd be fantastic. Thank you.
In the planning document.
Illustrative master plan. Yeah. Or if you want to be fast.
8.08.
Just bear with me a second.
That's what I've got on my screen. I think that's what you've got.
I've got the illustrative master plan, and just give the councillor a minute.
Bear with me. Yeah. Okay, got that. Okay, now this shows the proposal and it's illustrative, but there is a landscape buffer plan as well, and we're willing to be conditioned to that. Now, if you look at the northern part of the site, and I'm taking that from the cardinal points of the compass, you can see that the northern part of the site is intended to be green space. So there's a combination of open space and then various other green features. Do you see that? Yes.
Okay. I think that's an orchard there that's intended. Now, that area is not proposed to be developed, and we're happy to accept a condition that says it isn't to be developed. That's the highest part of the site, isn't it?
Yes.
Okay. Then if you come down to the footpath that connects, it goes along the southern boundary of the site, we've chosen not to develop the lower portion of that, particularly on the western part of the site. Do you see that?
Yes.
Okay, and we're happy to accept that as well by way of condition if necessary.
I accept the plan as I see it here.
Yeah, yeah. Okay, now this is a 4.6 hectare site. If my clients had sought to deliver, even at sort of suburban densities like the ones opposite, say 30 dwellings a hectare, they might have put 135 dwellings on the site. But because we've got a series of green areas, the proposal is only for 90 dwellings, isn't it?
Only, it's a significant site.
Yeah, that's perfectly fair, but it's... so, first of all, can I say, is there any advantage, do you think, in not developing, first of all, that northern part there, or do you think the impact would be just the same if we put houses over that northern area?
I would say that the committee made a decision based on what was put in by the applicant.
Yeah.
It isn't to redesign the scheme.
I'm not asking you to redesign it. I'm asking you whether you think there is any advantage in not putting houses in that area.
Well, we made a decision based on what was submitted. I don't understand why you would want to change it during the appeal process of an application which is as stated.
I'm interested in whether you think it's an advantage not to develop in that area.
I think the proposal footprint significantly narrows the green wedge.
I understand all of that.
Regardless of what options you may or may not present.
Councillor, you seem incredibly reluctant to answer straightforward questions. Why is that?
I think I'm answering all of your questions very succinctly.
You're not. I'm asking you whether you think there is any advantage in not developing that northern area. You must have a view.
Well, obviously, all developments needs to be sustainable, but obviously this is a green wedge development, and so we've made it clear that we didn't feel that was
I think the question is specifically about that northern part of the site. I don't know if you could...
Well, whatever development you propose, which isn't part of the CP18, what is expected to be allowed within CP18, would sigsignificantly narrow the green wedge, which is what you're proposing to do with this application.
Councillor, I'm going to have one last try. I'm going to suggest to not answer this as unreasonable, okay? Do you recognise any advantage in not developing that northern area?
I've recognised that the applicant has done what it can to mitigate the impact on the green wedge, but that doesn't negate CP18 and the decision that the planning committee
nobody's
made.
Doubting CP18 is relevant to your case, but it's obviously an advantage not to develop in that northern area, which is the highest part of the site. It's obvious.
That's your opinion.
No, I'm asking yours.
Well, I've answered it.
Yeah, you think it's an advantage.
No, hang on. No, I didn't say that. I said that the footprint that you've proposed significantly narrows the green wedge.
Yeah. Okay, Councillor, recorded to say the appellant has done what it can to mitigate the impact. Yeah, okay, very good. So that southern area then, next to the footpath, is there any advantage to not developing that?
It's the same argument that we're going to go around in circles about, isn't it?
Yeah. So what I'm going to suggest to you is, as a councillor, and you're here as the witness of the council, you have failed to recognise any of the advantages of the proposed layout, haven't you? You've just basically treated this as if it was all being concreted over.
No, I don't agree. We made a decision in the planning committee based on all aspects. and its impact on the green wedge.
Yeah.
What the applicant has put forward does have green elements, footpaths, except that. That doesn't mean that it should have been allowed.
No, and I understand your case, but what we then deal with is the mitigation. And you see, I would have thought that a councillor properly directing himself might have thought, well, yes, obviously there is an advantage to not developing those areas. That's right, isn't it? There is an advantage to not developing those areas.
I think the point you're making is that the applicant has made steps to try and mitigate the impact on the green wedge.
Yeah, which
that
are welcome.
That is not an acceptance that it's acceptable in terms of the planning committee's
Councillor,
decision.
I'm not suggesting I'm going to convince you that this is acceptable. I don't think that's going to happen.
Yeah.
Okay, it's not kind of Cluedo or the Old Bailey. Okay, all I'm saying is let's be reasonable in our discussions here this afternoon, and let's recognise that there are advantages to not developing the full extent of the site, and that must be right.
Not if the impact of the other elements of the scheme
Okay.
outweigh those mitigations.
Okay, I'm going to suggest that's unreasonable, not to answer that.
No, sorry, sir. I believe I have fully answered that.
I know, but
The nuances isn't a yes or a no in that case.
Yeah.
It's the same way as that you maybe want to come back at me with a more...
Councillor, I'm
more
simply
description.
testing your credibility. I'm testing whether you'll accept sensible propositions or if you're being unreasonable, and I'm entitled to do that. I've given you several goes at that, and the inspector's got the answer, and I don't need to ask more, but I am entitled, and I'm just warning you in closing submissions, I'm going to say that you're being unreasonable. You're being unreasonable in not recognising the advantages of the layout, aren't you?
No, I've recognised that the applicant has taken steps to provide green space to mitigate the housing element of the application.
Okay. Now, looking at the site and looking at the master plan, if we look at the northern area, there's obviously the area that's undeveloped, and then to the west of our boundary, there is a large arable field. Do you see that?
Yes.
Yeah. That field is very much open, yes?
Yes.
And connects with the wider green wedge to the north, yes?
Yeah.
And there's quite a distinction in the character between the smaller development, the smaller fields where the appeal site is and that large field. There's a difference in character, isn't there?
Somewhat.
Yeah. And I'm going to suggest to you that the presence of that large open arable field ensures, in line with the policy, that there will continue to be the principle of a green wedge here. We are not cutting off the green wedge or removing the green wedge in this location, are we?
You're significantly narrowing the green wedge.
Yeah, and I understand that, and we disagree. You know, obviously, we don't think that's right at all. But what we're not doing, first of all, is we're not filling in the green wedge completely, are we?
Well, clearly.
Yeah. Secondly, we are not developing the large open field to the west, self-evidently.
Well, obviously the application site is before us. We know that that's the case.
Yeah. We are not actually developing in the narrowest part of the gap. That's right.
Well, I think there's a debate on that. You are significantly narrowing already the narrowest part of this green wedge.
Yeah, you see, we disagree with you. We don't see how you could possibly, with any credibility, suggest that. If you have a look at the eastern part of our site, from the aerial photograph that the master plan is imposed upon, you can see this suburban 1960s, 70s housing, yeah?
Sorry, whereabouts?
To the east of the site.
Yes.
Yeah, okay. And then if you look across where the site is, okay, we've got our housing development, we don't develop that northern bit, and then the map shows the the open arable field to the west, okay, and then Cheddar is to the west of that again, yes?
Yeah.
Okay. If you look at the area to the south, where there is the route through the gap, you can see, first of all, there is a road called West Road, yes?
Yeah.
And West Road takes you to the secondary school, which is the West Park Secondary School.
Yeah.
Yes? We can see where the school extends to. We can see their tennis courts as well, but as far as the buildings are concerned, you can see how far west they go, yes? Mm-hmm. We are not as far west as that. Are we?
Well, clearly not.
No, because the gap there between the buildings and the road, Acorn Way I think it is 300 metres, okay, from the nearest part of the building, right? And if you take the tennis courts, it's even less. I think it's 219 metres. Immediately north of those school buildings is a series of houses on the north side of West Road, yes?
Yeah.
Yeah, okay. And then we go further north to our site, and you can see where the edge of our site is by the red line, yes?
Yes.
But we've chosen not to develop in that first field going west to east. Do you see that?
Yeah, that's not in the green wedge.
It is in the green wedge.
The houses aren't in the green wedge that you just mentioned, I don't believe.
Yeah, oh, yeah, sorry, the ones on West Road, yeah, are not in. I'm just talking about the width of the gap.
Okay.
If we go north to our site, and you take the bottom southwest corner, hopefully that makes sense.
Yeah.
That we've chosen not to develop in that area, yes?
Yeah.
Yeah. That gap is 329 metres, and then if you go north...
That would be the primary school fields that you're talking about?
No, just on our site, so north
yes.
of that, yeah,
Okay,
yeah. I'm sorry, north of that, okay? And then we've got some housing development, and those two parcels that are near to the western boundary, they are the furthest west that we go, yes? Mm-hmm. Good, okay. And those are around 300 metres away, and my witness will deal with that. So actually the school and the tennis courts, they are, well, let's deal with the school buildings are around 300 metres from Acorn Way, aren't they?
Well, I can't tell on this map as to how many metres it is.
That's a fair point. We're going to ask the inspector just to have a look at that, and we'll go through that with our witness as well. I'm going to suggest to you it's not the narrowest part, but in any event, obviously one needs to think about the perception. One traverses the gap, i.e. goes from Cheddar to Spondon along the tarmacked path which goes next to the secondary school, yes? Okay. That's how you traverse the gap, isn't it? Yeah, and that's not possible where our site is because there isn't an east-west route from Chaddeston to Spondon. There's just the footpath to the south of the site that then goes to the farm buildings, yes?
It probably would be worth the inspector having a look at that because I'm not sure if there's public right-of-way currently or not across that site.
Okay, that's fair. All right, now one of the things we're doing was we're introducing obviously public rights-of-way through the site, and that includes the northern field or the northern area where it goes through the orchard. Do you see that?
Is that the red dotted line?
Yeah, the white dotted line.
Right. Also, yes, I've seen it. Yeah.
And so what we're doing is providing public access there where currently there is not public access, yes?
By building on the green wedge, yes.
No, where the orchard is, that isn't a building.
Well, the site that you are providing that public access to would be part of the development to build on the green wedge.
I totally accept that. We'll put our hands up. There is going to be built development here. That's our proposal. But as far as that public right-of-way is concerned, there is not currently a public right-of-way there at the moment, is there?
Well, clearly, because it's not developed for housing.
Yeah. So what we'll now get is people will be able to walk either from the residential areas to the east, so Royal Hill Road, or they might come up from the secondary school and the footpath there, and they'll be able to link in to the wider network of public footpaths by passing through our development and then through the orchard and then the open space, and then they'll connect with the public right-of-way network that is in the top north-east corner of our site, yes?
Yeah, I don't think the benefit of that would outweigh
No, no.
the harm that the building on the green wedge would.
Councillor, I don't disagree. I'm not going to put to you that that footpath alone is going to outweigh the benefit. The benefits are many other things, but what I'm saying is we are providing a connection through areas of the development, including the open space at the northern end, which will allow people to connect to the public rights of way network.
Yeah, which is perfectly normal for all developments.
Yeah, absolutely. And if you can do it, great. Sometimes you can't. There's ransom strips and there's lack of land control and so on. But if you can provide that kind of route, then new development should seek to do that, shouldn't they?
Well, clearly, nobody's debating the fact that the applicant has put forward what they feel is a very robust application. The committee disagreed. But yeah, the design elements that you're suggesting are common in many developments, whether they be large sites or small pockets of housing.
Yeah, it depends on the developer. No bus connection between Bolton Moor and the adjacent Bellway development south of Derby because the landowner wasn't prepared to allow that to happen. But here we've got a landowner with access to the corner of the site that allows it to connect to the public rights of way network. Yes,
and that is something which I can't think of one small or large development that's come forward or has been built out in the Derby vicinity, whether it be an urban extension or within the city, that doesn't have these kind of design elements. It's very common.
Yeah, all I'm saying is the huge site at Bolton Moor, the landowner got greedy and wouldn't allow access through for the buses or the public transport.
There's always exceptions.
Yeah, there are, and there's one about 3 miles away. Okay, so in terms of the site, I put to you why we say it's suitable. I put to you about the nature of the gap. There will still be a green wedge in this location, penetrating down to the secondary school and further south. Even if our development goes ahead, there will remain a functional green wedge, won't there?
A reduced green wedge, yes.
Well, there will remain a functional green wedge. That is right.
There will remain a much smaller green wedge.
That's not the question, Councillor.
He said yes.
He said yes?
He said there will be a functional green wedge, yes.
Good, okay, but then, forgive me, it probably must be time for an afternoon coffee. Yeah, if that's a convenient moment. So.
Okay, thank you. Yeah. Should we say 3:35?
Yeah.
3:35 we'll reconvene. Obviously, it still applies to you to
stay here
in isolation. Yeah. Thank you. Okay, thank you. before I come back to Mr Young to continue cross-examination, I notice a document has appeared on my...
Yes, sir. You've heard already today quite a lot about future plan making in Derby. This is the most up-to-date local development scheme, dated February of this year. You'll recall that all local authorities had to submit by a deadline in March, I think, to the Ministry, an up-to-date local development scheme. That's Derby's.
Okay. The appellant's got no comments with respect. Okay.
And that'll be, I think, 12.07.
Yeah.
Well, up to 12.05 have been uploaded already.
Okay.
So we're not doing too bad. Good.
It's very prompt, yes. Thank you. Okay. I'll come back to you, Mr Young.
So can we go back to the core strategy and back obviously to policy CP18? Okay. If we have a look, please, at the end of paragraph 5.18.6, it says, any review... sorry, are you there? I'll just give you a minute to get there. .18.6. Are you there? Can I just ask?
Oh, sorry, yes,
yeah,
I said
okay.
that.
So, any review of boundaries, it says, will be taken within the context of maintaining the principles of Green Wedge as set out in this policy and the objectives of the plan. So, what it admits to there, obviously, as we've seen, is the potential for amendments to the Green Wedge and to identify the non-strategic housing sites. And this, of course, is a non-strategic housing site, isn't it, given its scale?
It's still a significant site. 90 houses is not a small development.
Yeah, no, that's fine, but we're not disagreeing with my point. It's not strategic, and therefore maintaining the principles of the Green Wedge as set out in the policy and objectives of the plan. And if we want to think about what the principles, the objectives and the principles are, we go to Part K, and it says if where urban extensions occur, the principle of the Green Wedge itself will continue. So the inspector needs to ask himself the question, if I allow this appeal, will the principle of a Green Wedge between Cheddar and Spondon exist? And the answer will be yes, won't it?
The principles of Green Wedges in the round, yes.
Yeah, good, that's fine. So it will exist, and that remains the case. So we're then into an issue about, well, given all of that, what weight might the inspector give to the benefits of the proposal? We haven't heard any live evidence, and local people haven't heard any live evidence, and I appreciate they're not going to read all the proofs of evidence about the affordable housing position in Derby. But the position is that the size of the housing waiting list of your own residents now exceeds 8,000 families and individuals, doesn't it?
Yes, and approximately, I think it's a bit less than that, but and that's not uncommon across the UK in terms of authorities.
Yeah, no, it is. No, I don't know that many who've got 8,000. It is partly a product of the size of the city, so that is obviously a feature. But that seems to be your answer to everything. It's a bit like the Three Yorkshiremen sketch. You're giving me an answer every time that says, well, you know, it's not, you know, it's not as bad as others, or we're in the same position as others, or my goodness, you know, we had it tough. It's not an answer to having 8,000 households on your waiting list to say, well, that's not uncommon. There's a housing crisis in this country, isn't there?
There's a need for more housing, yes.
There's a housing crisis in this country, isn't there?
It depends on, you maybe word crisis, there's a need for housing, I would say.
There's a housing crisis in this country, isn't there?
That is your opinion?
No, it's not my opinion. It's what Nick Bowles, the Conservative Minister for Planning, admitted in a parliamentary debate in October 2013, and it's been recognised by the government. the previous government for over a decade. There is a housing crisis in this country. Yes or no?
Derby's playing its part to address that.
There's a housing crisis in this country. Yes or no?
There's a significant need for housing in this country.
There's a housing crisis in this country. Yes or no?
It depends what you mean by crisis. It's subjective.
Okay.
There is a very significant pressure or a requirement for a significant amount of housing in this country to be delivered.
Councillor, I know which party you belong to. I know your own Minister of Planning accepted that there was a housing crisis over a decade ago, and it certainly hasn't got any better. So the question is, do you, sitting there as a councillor, with all the responsibility that takes, do you even recognise there's a housing crisis? And the answer is, Mr Young, I don't recognise a housing crisis in this country, do you?
That's not the case. And can I just say, sir, that it's important to state that the decision that was made in the planning committee is nothing to do with politics. We walk into that chamber to make a decision without whips. Politics does not come into it. It can't by local, well, national laws.
Yeah.
So suggest somehow that I have political bias towards whether there's a need for housing or not, I don't think that is fair.
There's no political bias being suggested in the question.
Well, you
in
raised
fact,
Conservatives.
I'm helping you with the fact that the planning minister in 2013, who was Conservative, admitted there was a housing crisis in this country. Some of the backbenchers didn't agree with him, but that was the government's position. And I'm simply asking you, as a councillor in Derby, with over 8,000 people on your housing waiting list, whether you recognise, first of all, there's a housing crisis in this country. And your answer, I think, is, after not answering 5 times, your answer is, no, I don't think there's a housing crisis.
No, I didn't say that at all.
Okay,
I recognise that there is a significant pressure and need to deliver housing.
But that's not my question, and it's very interesting, but it's not my question. My question is, do you admit there is a housing crisis in this country?
I admit that there is a need for housing.
Is there a crisis, a housing crisis?
I've answered the question.
Okay, all right, okay. I've got a note, because I'm entitled to get a note, that you wouldn't admit that. So,
No, sir.
No,
it's subjective about define crisis. Crisis in terms of there is a need for significant housing growth in this country. I definitely agree with that.
Yeah, a crisis is when we're not managing to cope with the problem, and we're not managing to cope with the problem. Do you recognise that?
I recognise that the local plans in the HMA have delivered very significant housing. We've seen thousands of houses delivered in this area, including social housing. The councillor are putting forward CPOs to do what they can as well to deal with the people that need housing. I don't think it's fair to force crisis when we can both agree that we need housing to be built.
I know we need housing. I am aware of that. My point is, will you answer the question? I've given you several attempts to do it. The inspector has indicated for me to move on. I am entitled to record in the closing submissions what I'm entitled to record, which is that you haven't answered that question. Okay? You may disagree, but as long as I put it to you and give you a couple of goes at it, then that's fine from my purposes. So is there a housing, with over 8,000 households on the housing waiting list in Derby, is there a housing crisis in Derby?
There's a need to deliver housing to ensure that those people can have homes to live in, yes.
You deny there's a housing crisis in Derby,
No, I'm not denying that there's a need for significant housing.
Okay, well, I'm not going to repeat it 5 times. I've got the answer, and you know what I'm going to say in closing submissions. So, the 8,000 households, the council obviously takes responsibility for housing them, yes? Mm-hmm. Yeah. What did you spend on emergency temporary accommodation last year?
That's something I have to look into.
You don't know, do you?
Well, do you expect me to know off the top
of my
head?
I expect you to have a really good handle in a housing case, which is bringing forward new housing, which is within the city and delivering affordable housing, unlike nearly all the city centre development. I expect you to understand the scale of your housing problem by knowing the number of people on your housing waiting list, and in particular, how much of your budget you are spending on temporary accommodation. And I've given you the opportunity to answer that, and you just don't know, do you?
No, it's very significant, but I don't think it's fair for me to be able to pluck out the exact figure off the top of my head. It would need to be something I have to look at because it's a very moving target.
Yeah, that's the difference between professionals like Mr. Lees and yourself as a politician. Professionals do record in their proofs of evidence. His proof of evidence, have you read it? So, Mr. Lees, just help me with this. Have you read Mr. Lees' proof of evidence?
Yes.
Have you read Mr. Stacey's proof of evidence?
I've written all the documents here, but it doesn't mean to say I've memorised them to actually pull out statistics without actually referencing back to them.
I would suggest that a councillor in a council that's spending millions of pounds on temporary accommodation, resisting a proposal which actually in the city delivers affordable housing, might know how many millions of pounds were spent on temporary accommodation last year. You do not know.
I could find that information out for you if you need it.
That's not the purpose of my question. We have that information, and the point is I'm interested to know, in opposing proposals and appearing as a witness, what you have an understanding of in terms of your identified affordable housing need. Do you know what the annual affordable housing need is that the City Council itself identified?
Before you go further, obviously I have already set out, I don't want to hear any detailed submissions further on affordable housing. We'll by all means ask this question and continue, but just bear that in mind. I have set that out as a position.
Okay, all right. It is obviously part of our case to highlight the fact that last year, in the first year, 2023, of your LHNA, which is your local housing needs assessment, you actually managed the extraordinary achievement of delivering a net negative number of affordable housing when the right to buy purchases were taken into account. So 372 affordable dwellings was your own annual requirement, and you ended up with a shortfall of 749. So you managed to actually see a reduction in your affordable housing stock against an annual requirement of 672. Were you aware of that?
Yeah, but via the current local plan, which has identified up to 11,000 houses, I think I'm right in saying bar one development I'm aware of, the strategic sites and even the smaller sites have delivered approximately 30% affordable housing. I don't think it's right to suggest that Derby City hasn't done what it can, either directly or with its HMA partners, to deliver as much social housing as it possibly can, including some CPOs to release housing.
You think you've done as much as you can. You didn't do the Part 2 review. You have not allocated further sites. You haven't got an up-to-date plan. You failed the housing delivery test. You spectacularly failed the 5-year housing land supply test, and you managed to deliver a net loss of 749 affordable homes last year alone, and you think that's a success, don't you?
Well, so, for example...
you think that's a success?
I didn't say it was a success.
It's a disaster, isn't it? It is an unmitigated, catastrophic failure in affordable housing delivery that your council is your council is presiding over. An unmitigated and catastrophic disaster.
No, I think that the council has done what it can, is working very hard to deliver as many social housing units as it can, dwellings. I'll give you an example of the South Derbyshire local plan, which is proposing 2 major strategic sites with up to 40% social housing, and they will tell you in their local plan that that is for Derby's needs or partially for Derby's needs. So I think there is significant evidence that both Derby and its HMA partners have done what they can realistically to deliver affordable housing, and there's evidence now emerging that is in the public domain which shows that they will deliver significantly more.
So why do you think there's such a spectacular failure against your own figure to the tune of 749 affordable homes against your own figure in terms of the net loss last year?
Delivery of housing, strategic sites, large sites, is a challenge. And again, I will say it again, it's not uncommon to have these difficulties. It doesn't mean that we're not trying to address them.
Yeah. the inspector doesn't want to hear too much on this, but of course, each of these people that is on the housing waiting list, or each family, because it's households, of the 8,000, or the 749 net loss last year, each one of these are households in housing need now, aren't they?
Yes, but I understand where you're going with this, but let's just, if I may, focus on the decision that we made. Your argument does not mean that we should be building on the green wedge.
It does. It does. You should be building on parts of the green
that's your
wedge.
Opinion.
No. You've asked me a question, and that's not conventional, but let me answer it for you by asking you a question. Do you not recognise that the whole structure of your local plan means that the green wedge is a legitimate location for urban extensions, and that you can deliver affordable housing on green wedge sites? Not all of the green wedge, but some of it. It was meant to be done in the Part 2 plan. You haven't done that. We've come forward with an application. It is on the green wedge. We've chosen an area which is particularly developed already, and we are delivering 30% affordable housing. So we are seeking to address some of your affordable housing need problems on this site, aren't we?
And of course, the decision of the committee, because this is what the appeal is, was based on that would not be acceptable in terms of building on the green wedge. And I've already said that the local plan is the place to look at all aspects of this, whether it be green wedge, social housing, aspirations for how much social housing should be delivered via strategic sites and smaller sites. That's the place to make those decisions. I don't accept that the inspector should make a decision based on the fact that it's delivering social housing that therefore justifies building on the green wedge.
So you say it should all be through the local plan process, but obviously we don't have one, and we don't have the Part 2 plan, and that's 7 years late. So as far as paragraph 11 is concerned, you referred to it earlier, the tilted balance. What does the tilted balance do?
Okay, so tilted balance. Let me get this in context of the decision that we made. So it's a decision-making framework included in the National Planning Policy Framework, which applies when a local authority can't demonstrate a 5-year supply or deliverable sites. And our argument is that CP 18 is still, even with that accepted, CP 18 carries enough weight for us to make the decision that we did.
Okay, so my question is about the tilted balance. What is the tilted balance? What does that mean?
I've just told you.
Yeah, you said you continue to think that CP 18 is determinative in this case, but I'm asking you what's the mechanism? So, first of all, what's the test to be applied when the tilted balance, because the tilted balance doesn't appear there. That's a phrase from the Supreme Court case that Mr. Richards and I did. It's a phrase that was used in skeleton arguments, and I'm not going to claim total ownership of it, but the court ran with it, and everybody else seems to have run with it. What is the tilted balance? I understand you think CP 18 determines the outcome of this case, but what does the tilted balance mean?
Approval is presumed unless adverse impacts significantly or demonstrably outweigh the benefits.
Okay, so in terms of plain English then, significantly and demonstrably outweigh the benefits, what sort of test is that?
5-year supply, NPPF policies.
Yeah, it's a significant reversal of the statutory test, isn't it? The statutory test is you make the decision on the basis of the development plan unless material considerations indicate otherwise, yes?
Yeah, which is what I've said about the decision that we made, which is CP 18,
yeah,
which we felt.
But what happens with the tilted balance is you effectively change that completely because there isn't a presumption in favour of the development plan. What the council have got to do is show that the adverse impacts, i.e. the harm, significantly and demonstrably outweighs the benefits. So it's a completely different test, isn't it?
Well, in the context of the decision that the committee made, CP18 was the reason for rejection.
That bit I understand, but that's not my question. My question is, the significantly and demonstrably outweigh, that is a wholly different test to the statutory test, isn't it?
Yes.
Yeah, and as a consequence of which, the inspector's got to do two things. First of all, he's got to identify the adverse impacts, yes?
Yeah,
The adverse impacts of obviously granting planning permission, yeah? And then he's got to ask himself, what are the benefits of the proposal, yes?
Of course.
Yeah, and having done that, I've got two sides of the scales. The reason it's tilted is because it's very much then tilted in favour of the developer, because what you've got to show is those adverse impacts significantly and demonstrably outweigh all the benefits, yes?
Yeah, exactly the same process as the planning committee made.
Yeah, so in terms of that process then, let's think about this. The only adverse impact is the only reason for refusal, and the only reason for refusal is the reference to the green wedge, yes?
Correct.
And we know, I've already rehearsed that, but that's out of date. And as a consequence of which, I'm going to suggest to you that should be given limited weight. And that's right. If something's out of date, you've got to reduce the weight to be given to it, haven't you?
Well, we've had many conversations during this session where I have countered that with the process that we're undergoing in terms of the local plan, which you suggest won't come forward, and I say that it will.
Which is, there's no weight to be given to that, and we've already been around that track. But the point is, as far as the adverse impacts are concerned, one reason for refusal only refers to the green wedge. The green wedge is out of date. If it's out of date, obviously, the inspector's got to give it reduced weight, self-evidently, hasn't he?
Yeah, I mean, we're very proud of our city spatial feel, and the green wedges are an extremely important part of that.
Nobody doubts that's how you feel about it, but I'm just going through the MPPF tests, and then the significantly and demonstrably outweigh. So you've very obviously got to show that that adverse impact, which is from a policy which is out of date and to which reduced weight should be given, it still significantly and demonstrably outweighs all the benefits, yes? That's what you've got to show.
The committee disagreed on that. For example, narrowing of the green wedge and retaining a green wedge between two established communities, for example.
Yeah, and there's still going to be a green wedge because we've looked at that field.
Much narrowed.
Yeah, let's be clear. The western part of this gap, do you recognise any difference between the western part of the gap and the eastern part of the gap?
Obviously, clearly, geographically, there are differences, but I think we've been round the houses on this argument.
I'm just interested to know if you think there's greater importance attached to the western part of the gap, i.e. the bit we're not in, than the eastern, or do you treat them the same?
In terms of the appeal, we are dealing with what your applicants have actually put forward.
I am aware that we're dealing with our site, but I'm just asking you a different question. Sorry, Councillor, you don't need to tell me we're dealing with our site. I have, I don't want to be sarcastic, I have fully appreciated we're dealing with our site. My question was different. My question was, do you recognise a difference between the western part of the gap in this area and the eastern part, which we are in?
I think we've established that there are several differences in terms of the geographics and buildings.
Yeah, okay, good. All right, that's very helpful. Now, in terms of the benefits, then, obviously, to carry out the exercise, you've got to know what the benefits are, and in your proof, you admit to the benefits, don't you? You admit the benefits that this proposal delivers, yes?
I would say there are benefits to general housing growth if it delivers sustainable development, if it delivers our housing needs, housing targets, and if it delivers social housing, outside of the context of disagreeing with this particular green wedge being built on.
Yeah. Now, as far as sustainability is concerned, that isn't a reason for refusal in this case, is it?
I didn't say it was.
No, good, that's fine. And as far as the affordable housing is concerned, that's another especially important point, and we're delivering what is required by the policy, yes?
Yeah, and the point I made was that there are many other developments that will deliver social housing are doing and will do in the future.
Yeah, and you pointed to what's going on in South Derbyshire, and nobody here is criticising South Derbyshire. They're not the planning authority. There have been some urban regeneration schemes which have been taking place here in the city centre of Derby, haven't they?
Obviously, we are very compact. I think I may have mentioned it earlier.
Just a yes or no would probably do.
Well,
Are there developments taking place in the city centre?
Clearly there are, yes.
Yeah, and just help me with that. What sort of affordable housing is being delivered on the sites in the city centre?
We always aim, via the planning process, to aim for 30% on average.
Yeah, but you don't achieve it, do you?
It depends.
The answer is mostly
sometimes
no.
we don't. And then that is sometimes in the gift of the developers coming back and trying to renegotiate, which is past the decision-making process.
Yeah, absolutely, and they may renegotiate on the basis that they've got evidence to show it's unviable. They might want to secure the principle, get that established, and then come back. And of course, if they've got the evidence, they will succeed in persuading you or persuading the inspector. But the fact is, there's an awful lot of development coming forward in the city centre, which is very welcome as regeneration, but it doesn't deliver affordable housing, does it?
No, and what you've, no, it's not true to say that it does not.
No, most of it doesn't deliver affordable housing.
I don't know whether that's true, to be honest with you.
Well,
and I think you've demonstrated there that developers, whilst you're arguing that developers are delivering affordable housing, it is the case that developers sometimes go back on that.
Absolutely they do, yeah, particularly on...
So that just shows you another challenge that we face in terms of ever-moving goalposts.
Councillor, I don't disagree. I'm not here to defend city centre developers who have identified a route to securing planning permission. I'm not here to criticise the regeneration of Derby. What I'm here to do is just identify, for the relevance of our case, the comparison between sites that don't deliver affordable housing and sites that do. We have, not unusually for a greenfield site, sought to deliver 30% affordable housing. Given the size of your housing waiting list, then the delivery of affordable housing on this site is a matter to which the inspector should give significant weight, isn't it?
Well, clearly, affordable housing is something which the inspector will look into very closely.
Yeah, that's not an answer to my question, though.
Could you answer the question, please?
He will give it weight, yes.
No, that's not an answer to my question, though.
Rephrase it then, please.
It is a matter to which the inspector should give significant weight, isn't it?
One of many, yes.
Yeah, good. In fact, what's clear, and it's in the Statement of Common Ground, it's a matter to which, I'm surprised you don't know this, it's a matter to which the inspector should give very significant weight, isn't it? Yeah, good, that's fine. And for your notes, sir, that is paragraph 1.10 of the Statement of Common Ground. In addition, when you haven't got a 5-year land supply, then the delivery of housing that will help address that shortfall is, again, a matter to which very significant weight should be attached, isn't it?
It is, but again, I'll go back to the fact that we're talking about a green wedge here.
Yeah, that's a different question. So if we think about other benefits, then we're providing open space, including the orchards, the open space areas on the northern site and to the southern part of the site. Those are matters to which significant weight should be attached, aren't they?
And you're doing that by proposing to build on a green wedge, which we've clearly stated means a hell of a lot for this city in terms of its green lungs and establishing space between two communities.
Yeah, there'll still be a green lung, to be clear. There'll still be a gap between the settlements. There'll still be an area. But what we're doing is providing areas which are open space, fully publicly accessible, and that is a matter to which significant weight should be given, isn't it?
The planning committee obviously did that in terms of the application. We looked at it very closely, and it's a matter of balance as to which way you go.
It's a matter of balance, but I'm just trying to establish what weight you give to the provision of public open space and public access where currently there is none.
You give it weight in any application that you're considering via the committee.
Not the question, Councillor. What's the question? Do you think?
The question is, what weight do you give it?
Yeah, I'm asking you what weight. You should give it significant weight. The inspector in the decision-making should give it significant weight.
Along with many other factors, yes.
Good, okay, that's fine. Very significant weight. Okay, now economic benefits. When a new housing development is built, then obviously it employs lots of people. It involves bricklayers, it involves bathroom fitters, it involves salespeople, it involves lots of things. Those economic benefits, do you recognise them as benefits of the scheme?
Yeah, but in the context of building on the green belt, then I would say
Green
that
wedge.
somewhat...
Green wedge,
sorry.
I did the same
Apologies.
thing.
Green wedge.
Okay.
That argument wouldn't be as strong,
Okay,
in my
so-
opinion.
Yeah, you see, that's where we're going wrong, I think, is you're mixing the adverse impacts with the benefits. When you build houses, you employ people, and those houses, when they're being built, generate income. Often, even a scheme like this can deliver, 50, 100 million pounds of gross development value. Those are benefits. Just because it's in the green wedge doesn't mean you reduce the benefits. It just means you give weight to the adverse impact, and then you give weight to the benefits. Do you understand?
Yeah, but what you're saying here is that you're asking me to treat a proposal in the green wedge exactly the same as a brownfield site.
No, I'm asking you to recognise the benefits of the scheme. The fact that it's in the green wedge is an adverse impact. We accept that. We haven't come to this inquiry saying anything else. The benefits of building new houses and the economic benefits of doing that are on the benefit side, and that doesn't matter whether they're built in the green wedge, it doesn't matter whether they're built in the green belt, and it doesn't matter whether they're built in the city centre. The point is, that is a benefit in terms of the economic benefits that derive from building homes, yes?
And I think
So that's an agreement,
if we could settle this, I mean, obviously you can keep asking me questions, but I think I would draw your attention to the statement of common and uncommon ground, because there's a significant amount of common ground which we actually agree on. Yeah. And many of the things that you're asking me are actually are things that we don't disagree with.
Yeah, absolutely. But there's been quite a bit of a disagreement during cross-examination, and what I'm keen to do is just get a clearly established position on the benefits of the scheme. The biodiversity net gain in this scheme is how much? Do you know how much we're delivering?
30%.
The hedgerows is 25%. The actual biodiversity net gain in terms of the flora and fauna outside of the hedgerows and outside of the water related areas is 11%. 13? Yeah, 11, forgive me, 11 for habitats. Yeah.
Sorry, sir, so are we adding those together, or is it an
No,
average?
there's three components when you look at biodiversity net gain. There's those related to water, so benefits associated with having water. There's hedgerows, which is a separate category, and then there's habitats. The main one is the habitats, and I'll be corrected if I'm wrong, but my understanding is the benefit there is 11%, okay? And that's the main component of the BNG. That 11% is not something we are required to provide by statute, because the application was submitted before the statutory provisions came in. So that is a pure benefit. Do you recognise that?
Yes, with the context that we've argued about many times in terms of the green wedge.
Yeah, okay. So we've got a whole series of benefits now. We've got very significant weight to the affordable housing, very significant weight to the meeting the shortfall of the five land supply, very significant weight to the open space. I'm going to suggest to you that as far as the BNG is concerned, that is a matter to which significant weight should be attached as well. Do you agree?
As is the case for all applications, yes.
Yeah, okay, good. Well, not all of them, actually, because they don't need to on the non-statutory
All similar applications.
statutory basis. Good. Now, we could get into a long exercise about how much weight we give to each of those. I was just interested in your sort of reaction to those as we went through them. So I've got all these benefits on the one side, and we've got the green wedge on the other, and it's a question of whether they significantly demonstrably outweigh them. That's ultimately a matter for the inspector. What he must do is correctly weigh the adverse impact of the impact on the green wedge, yes?
Yeah, that's his job.
He must ask himself, does this fill in or close off a section of the green wedge? That's a legitimate question, isn't it?
Yeah, it's one of his considerations.
Good, okay. He must also ask himself, well, will people be able to access or see a green wedge from public vantage points? And obviously he'll look at the public footpath network in terms of that, won't he?
Of course.
Yeah. He'll also ask himself about any new footpaths and what the view might be from there. And he will also need to consider, won't he, whether we effectively close the gap and fill in the gap for the area to the south. And self-evidently, we don't build in the gap where the primary school is, because the primary school is already there, yes?
Yeah, and our focus is the narrowing, not to the south, narrowing the width.
To the north, yeah, okay. Now, as far as decision-making is concerned, this council, as you've quite rightly identified with the local plan work, has a dedicated team of planning officers who work hard on planning for the council, don't they?
Yes.
Yeah, they are dedicated officers, they are professionals, and they reach professional judgments based on their training, their qualifications, and many, many years of experience, sometimes 20 or 30 years experience, yes?
Yes.
Yeah. We've heard about councillors coming in at various stages. You have to remind me again, when did you become a councillor?
2008.
How many hours training have you had, do you think, since then?
A lot.
A lot, yeah. Okay. And in doing that, you've obviously had to think about the MPPF since 2012, yes?
Yes, and all aspects of planning.
We've discussed that already. I don't want to go back over that. You are obviously aware of the instruction in the 2018 version of the MPPF that requires local plans to be up to date, yes?
Yes.
Now, interestingly, your core strategy has a policy about the presumption in favour of sustainable development, doesn't it?
Yes.
Yeah, and it effectively applies a tilted balance as per the MPPF, yes?
Links to it, yes.
Yeah, and we know that there's a distinction because the MPPF Part 11D has been changed with some extra focus on affordable housing, using land efficiently, etc., which came in the 2024 version last year. But basically, apart from that distinction, which emphasises 5 particular areas for the inspector to consider, the fact remains that there is a presumption in the plan which requires the inspector to ask himself, in the absence of a 5-year land supply, do the adverse impacts significantly and demonstrably outweigh the benefits, yes?
Yeah, the same that the committee considered.
So we could comply with, if the inspector says, well, I think the benefits of this scheme are not outweighed significantly and demonstrably by the adverse impacts, or anywhere beyond that. So he may say, well, I think the benefits outweigh the adverse impacts significantly. But so long as he answers that one question, do I think that the adverse impacts significantly and demonstrably outweigh the benefits? Answer no. Then this proposal would comply with the development plan, wouldn't it?
That's the matter for the inspector to decide upon.
Of course it is, but the point is, do you accept that the inspector could, in this case, because of your policy, embracing the presumption in favour of sustainable development, if he were to conclude that the adverse impacts do not significantly and demonstrably outweigh the benefits, then he can find this proposal complies with the development plan?
That's what he's got to decide upon.
Yes, yeah, okay, so he can reach that conclusion. So then, if that were the case, we would look at ironically, paragraph 11C, because that says, in decision-taking, which is what Inspector Smith needs to do, approving development proposals that accord with an up-to-date development plan without delay. Do you see that? Mm-hmm. If he were to conclude that it complies with the development plan because of that policy, then it would comply with the development plan, and as a consequence, the MPPF says it should have been granted planning permission without delay. Yes.
Man, I think you're using your crystal ball again, though.
No, I'm simply looking at the words because the words make clear that it's without delay. So if this should have been granted, in the inspector's conclusion, this should have been granted because it complies with the development plan, then it should have been granted without delay, shouldn't it?
I think you're preempting the decision of the inspector.
No, I'm not. I'm asking you your opinion and to see if we can agree that if the inspector was to reach that conclusion, then it's a decision that should have been granted without delay. That is right, isn't it?
The decision will be made by the inspector as he sees fit based on all the evidence.
Don't doubt that, but that's not the question I'm asking you. Would you
I
like
think
me
I've
to put
answered
it?
it.
No, you haven't.
Well,
you haven't.
He's going to consider all evidence and draw to a conclusion.
Yeah, and
He may follow exactly what you've said. He may not.
Yeah, but that's not my question. My question presupposes he's reached that conclusion, okay? And I'm asking your professional opinion, well, I'm asking your opinion, not your professional opinion, I'm asking your opinion as a councillor. If he were to conclude that the proposal complies with the development plan because it satisfies the presumption in favour of sustainable development in the plan, then it should have been granted without delay. That is unquestionably correct, isn't it?
I'll go back to suggesting what the inspector may or may not decide.
Yeah, I'm not asking you what he may or may not decide.
I think you're making a statement of fact. You're not asking me a question.
No. I'm not saying the inspector has made his decision because nobody knows. That's how the whole process works. What I'm saying is, if he were to conclude that, if he were to conclude that it complied with the development plan, then the MPPF says that it's a decision that should have been made without delay. That's right, isn't it?
I think I've answered the question.
No, you haven't, but it doesn't matter. Now, the slight fly in the ointment, which the Secretary of State pointed out in a big case to Bloor Homes in Birmingham, is you can't actually pray and aid 11C if the plan isn't up to date. Your plan isn't up to date, so unfortunately 11C isn't available to us, is it?
Yeah, and I think we've covered this ground before, but I strongly believe that a decision on whether we build on Green Wedge or not should be part of the local plan process, not this appeal.
Yeah, nothing to do with my question, though, so let's try again. You need to comply with Part 11C, a development plan that's up to date, don't you?
Technically, yes.
Yeah, and your plan isn't up to date, is it?
We've got a local plan in place until 2028 with a
Your
one that's
plan
emerging.
isn't up to date, is it?
We are working on a plan to emerge this year that will
Your
update
plan
the local
isn't
plan.
up
Could
to
you
date.
answer the question with a yes or no?
No.
No, your plan isn't up to date. Good, okay. And we know that because the housing requirement isn't an up-to-date housing requirement, is it?
We currently aren't supplying the amount of houses that we should.
Yeah, it's not, I don't think that's a disagreement. So you don't have the up-to-date housing requirement, you don't have the right number, the plan is out of date, you're building the wrong amount of houses, and you're not even building those because you haven't even got a 5-year land supply. So the point is, your plan really doesn't have a great deal of relevance as we sit here in 2025, does it? Because it's based on the wrong numbers, doing the wrong thing, and it's not even managing that.
It was the decision of the committee, and I strongly believe this as CP18 is relevant, and that's the reason why we rejected the application.
It's got nothing to do with my question, though, has it? My question is, you haven't got an up-to-date plan, you've got the wrong numbers, and you can't even meet those, and that is the truth of it. We've got authority here with complete alienation of its responsibilities to have an up-to-date plan based on up-to-date housing figures. You've completely alienated responsibility for that, haven't you?
No, I disagree, and I still don't think that would mean we should concrete over our precious green wedges.
And Councillor, the last councillor who spoke, in fairness to him, had only been in position since the last couple of years, and it's not really fair to criticise him for things that have not been done since 2017. Things promised to be done to the inspectorate, but not done. But that doesn't apply to you because you've been a councillor since 2008, is that right?
Yes.
So you've got complete ownership of this, haven't you? You are completely responsible as a long-term councillor for the dismal failure in this authority's dismal failure in this authority's constant and repeated failure to produce an up-to-date plan.
I don't think it's fair to suggest that I'm solely responsible for...
No, not solely, but you are one of the councillors who is in this council and who is partly responsible for the abject failure in plan delivery in Derby?
I don't agree that it's an abject failure. If you speak to residents around the city who've seen major housing growth, they've seen thousands of houses being built as part of Derby City's need, and social housing, affordable housing.
Probably not the 8,000 households you've got on your housing waiting list. They're probably not singing your praises quite so loudly, are they, Councillor?
You may benefit from speaking to those people that have seen that's very significant growth. It's not true to say that we've abjectly failed in our housing delivery, because we haven't. We've delivered thousands of houses collectively with the HMA. I don't think it's fair to suggest that it's a complete and utter failure.
No, the plan making is an abject failure. In terms of the delivery of housing, you know, in fairness to you, houses are being delivered within Derby. They're also being delivered in South Derbyshire. South Derbyshire have stepped up, and where you have failed to deliver, they have taken responsibility for the houses that you are not delivering, and they have sought to meet some of your housing needs, haven't they?
And I think you need to accept...
But is that right? They have stepped up.
Let me explain. As I've said, Derby City is a very compact city. There isn't enough room, enough sites within the city boundary to deliver the housing targets. Therefore, we work proactively with the HMA to deliver our need, and that has happened effectively and is still happening effectively. And as I've said, I don't think this council is failing in its duty to develop a local plan. I've been part of the working party and seen the work that officers are doing, and I think this year we will see a local plan which will fully consider the green wedges, fully consider all of the sites that we could deliver housing on, and will also work with the HMA partners in the round to deliver significant housing and step up to deliver the housing need that this area needs.
Yeah, look, the figures are there, the failure in the 5 land supply, the housing delivery test and so on. In terms of neighbourhood plans, Spondon does not have a neighbourhood plan, does it?
Not that I'm aware of, but that's something which the planning committee wouldn't necessarily delve into in detail. We were tasked with deciding whether this application was appropriate or not.
Okay. Pre-application engagement in the decision-making process. Miller Homes are actually based in Derby, aren't they?
I believe they've got more offices, but I think they have a Derby office as well as others.
They do. Yeah, they've got an office here at Pride Park.
Yeah.
They've been building in the city and around the city for a long time. They engaged in the pre-application process as you would expect them to, yes?
Absolutely, but that's not something which planning committee members would be part of.
Yeah. As far as their consideration of the site, they have sought to include green areas within the development as a response to the location, because it's a green wedge location, yes?
I think it's true to say that developers will put forward applications, whether subsequently the planning committee would deem them worthy or not, it remains to be seen, but developers put forward lots of different options and they have the duty to deliver all the different benefits that we've discussed.
Yeah, okay. In terms of landscape and visual impact evidence, the council hasn't itself produced a landscape and visual impact appraisal, has it?
No.
And the council hasn't put forward a landscape witness.
Not that I'm aware of.
No, there's no arguments here about the conclusions about the landscape and visual impact.
No, and I think going back to the statement of a common and uncommon ground, I think, you know, it states for itself how much we actually agree on and the areas that we don't agree on. And so I think we're going over ground which was initially put forward and accepted very early in this inquiry.
Yeah, there are a list of policies. If we just go back to we're nearly done, but if we go back to the statement of common ground, relevant development plan policies, the presumption we've talked about, which is CP1A. We've dealt with CP6, which is housing delivery, CP18, which is green wedge. As far as the other policies are concerned, placemaking, character, and green infrastructure, public green space, biodiversity, there's no alleged breach of any of those policies.
I think this has already been established in terms of the submission that we've made of what we agree on and what we disagree on.
Yeah, and so there's no disagreement with those, and
in the
delivering
context of this document.
sustainable transport and making it happen. There is, of course, still in the absence of a full, up-to-date local plan, even if we go back to what the council has produced in 2017, i.e. a core strategy, because that isn't a full plan, the City Council still relies on policies in the saved City of Derby local plan review, doesn't it?
Yes, I mean, as I said, the emerging local plan isn't ready yet, will be this year, but therefore we are going to be relying on policies that are currently adopted or older policies.
Yeah, so that was adopted in 2006. Now, I remember doing that examination in public. It was the last set where we were allowed to cross-examine a local plan inquiry. Yes, there are some familiar faces. And that is nearly 2 decades ago, yes? I think the examination was obviously 20 years ago. And what that tells us is that the council are still needing to rely for residential development, for example, on the general criteria policy H13, because you haven't got a full up-to-date plan, and you haven't even got a Part 2 plan. And as far as the Part 2 policies are concerned, the ones you rely upon are now nearly 2 decades old.
I think we've spoke at length about that particular aspect.
We're not
the local
this.
plan is currently adopted till 2028.
Not this, I've still got questions on this. You're relying on policies. I mean, I've only been at the bar for 26 years, and I mean, that was right at the start of my career, and you're relying on policies from 20 years ago. We didn't even have an MPPF in 2006. It didn't come along for another 6 years, did it?
Well, no, obviously.
No. So your plan making is so inadequate that you've only got half a plan, effectively, a core strategy. You haven't got the other allocations. You haven't got the development management policies. And in their stead, you rely on policies which are 2 decades old and post-date even the first version of the MPPF.
I believe that it's still relevant and up to date.
Yeah, but you think they're up to date?
No, I thought it was relevant and should be referred to in decision-making process. I don't think there's a problem with actually...
So procedurally you rely upon them in the absence of having an up-to-date Part 2 plan, but you recognise they're obviously all out of date.
Well, I recognise that they're from 10 to 20 years ago in some cases.
Yeah, I mean, how many councils in this country are relying on policies? I mean, you say, oh, we know worse than anybody else, or, you know, that's not true, actually, but you are a lot worse than a lot of places. But in particular, I mean, how many authorities are relying on policies which are 2 decades old?
If the policy is sound, then some may be. They can be amended, they can be updated. I genuinely believe that we have solid policies that we can refer to when we're making decisions in the planning committee.
Okay, well, Councillor, that's fine. Your position is you've got solid policies. I'm putting to you that you've got a development plan which is spectacularly out of date.
That would be your opinion, not mine.
Yeah. Okay, all right. Thank you very much indeed.
I don't personally, I've only got 5 what I hope will be quick questions.
Can I just take time just to clear this desk?
Yeah, that's fine.
Yes, I'm going to have just a few tidying up questions after this.
Carry on.
Thank you. Councillor Holmes, do you want to put your microphone back on?
There we go.
Excellent, and I'm now off the screen. Yes, I just want to ask you 5 matters just to tidy up a few loose ends, and I'm going to work backwards so that we are remembering, starting off with questions about the end of your evidence and working backwards through it.
Okay.
You told the inspector, in the context of the authority being proactive with its HMA partners,
Yes.
that you'd been part of a group that had seen what officers are doing.
Yes.
Do you know the name of that group?
Local Plan Working Party, I think, is
Okay.
the...
We've got in the evidence before us reference to a group called the Derby HMA Joint Advisory Board.
So that is for the cabinet members, the lead cabinet members of the relevant authorities to meet to discuss strategic matters.
Right. And so,
And I'm not part of that, it'd be the cabinet member.
okay, so sitting underneath that then is there some sort of working group, is there?
Yeah,
Is that of members?
Yes, a cabinet member, I can't remember which cabinet member made the decision as the local plan was starting to be talked about of our officer cohorts. They decided to form a working party. Each political party has nominated representatives. I'm one of those. And we work with officers proactively to look at what's being developed, obviously have input and work through towards, help work through towards the publication of a draft plan.
And again, in the evidence that we've got, there's reference to, not unusually, the City Council using some consultants to help with that work, in this case, an organisation called ACOM.
Yes, ACOM.
Have you been involved in any sessions with ACOM?
When I was cabinet member, I've been cabinet member twice, deputy leader of the council twice.
What, cabinet member for what?
For planning and regeneration.
Right.
That was when I wasn't on the planning committee. When I wasn't in those roles, I was on the planning committee. So throughout my career, if you like, as a councillor, I've always been involved in planning. Sorry, to answer your question, my dealings with ACOM is strategic reviews of the whole region. The what-ifs, where the housing could possibly go, doesn't necessarily mean that it would have been suitable, but they were, in my experience, when I was involved, looking at the whole region to identify potential sites.
Okay. Second question of 5. Can we please go to the committee report, which we have as core document 3.02. And in this case, you were being asked some questions about BNG.
Yes.
Which stands for Biodiversity Net Gain.
Which is a relatively new aspect.
Yep. And just what the committee was and wasn't told, really, is the purpose of my question. Page 9, paper and PDF page 9.
Is this the Royal Hill Road Spondon Terra Tech document? Or
No,
something else?
it's the committee report.
Hang on, sorry.
Core document, I've called it 3.02. I'm assuming that that's the right reference.
Let me find the relevant part here. It's just
Okay.
loading at the moment. Apologies, it's still loading. Unless you want to continue in
No, I just need you to draw your attention, first of all, to page 9. This is the section of the report dealing with consultation responses, and in particular that of Derbyshire Wildlife Trust, is what we're in at the moment, and the conclusions and recommendations of Derbyshire Wildlife Trust on page 9.
Yes.
4 lines down into the conclusions and recommendations section, the proposals set out to address the loss of habitat and hedgerow on site have been demonstrated by the BNG assessment, EA and metric to provide a greater than 10% net gain for habitats, hedgerows and watercourses in line with the MPPF. However, these proposals also meet the mandatory 10% net gain requirement that came into effect on the 12th of February. However, it's noted that this application was submitted prior to that date and therefore does not necessarily have to demonstrate a 10% net gain. So, was the committee fully aware of the fact that more biodiversity net gain was being supplied than was strictly legally necessary?
Each committee member would have this report, so if it's written there, then yes, they would have taken that into account.
And then I think, just for the inspector's note, we get the planning officer's conclusions on page 17, I think. No, page 20, that repeats that advice. In the paragraph that begins at the top of the page, the main benefits would be.
Yep.
Yeah, okay, good. Third question of 5. For this, can we please go to the decision notice at core document 3.01? And this comes in the context of you being asked questions about the tilted balance.
Yes.
And the first, on the decision notice at CD 3.01, can you find part 4, reason for refusal?
Bear with me a second. A little bit slow, it's coming up. Right. Okay. Sorry, part
4, do you see the bit on it?
Yes.
Part 4, reason for refusal.
Yeah, got that.
And it comes in 2 paragraphs. The first paragraph begins, in the opinion of.
Yes.
And that's the bit that sets out what the problem is so far as the green wedge is concerned in this case.
Yes.
The second paragraph begins, the local planning authority accepts.
Yes.
Do you see that?
Yes.
But this proposal should be determined in the context of the, and then it does the sort of air quotes, tilted balance, which has been invoked, and accordingly the relevant guidance in paragraph 11D of the NPPF has been duly considered.
Yes.
In this case, the proposed residential development would lead to the unacceptable narrowing of the Spondon and Chadston Green Wedge, and as a result, this important policy contravention would significantly and demonstrably outweigh the planning benefits.
Which is the nub of the issue.
Well, exactly right. Do you understand there to be anything wrong with the approach recorded in the
No.
decision notice? Well, we'll ask Mr. Lees whether he agrees with you or not tomorrow, probably. So that was the third question of 5. The fourth question of 5 goes back to when we were looking at the master plan, which is CD 8.08 off the top of my head. Yes.
Is this the layout?
Yes, that's it, the illustrative layout plan.
I've got that.
And we were looking at this in the context of you being asked questions about the advantages of the layout being illustrated.
Yes.
And it was, and you were asked questions as to you thought, for example, it was an advantage that the bit that's shown as the orchard, we think it is, and then the open space to the north, whether it was an advantage that that wasn't having houses built on it.
Yeah.
And then it was pointed out to you the bit in the southwest corner, which illustrates a largely open field, presumably going to be some sort of public open space, although it might be
Balancing pond.
wet in the winter and be a balancing feature. Yeah. And then the bit alongside the footpath in the south. And it was put to you that that was an advantage. And you were being asked questions whether you recognised the advantage. And what was being suggested to you is that you ought to be grateful that instead of coming forward with a scheme for 90 houses, the appellants have not come forward with a scheme for about 130 or 140 houses, and you ought to be grateful that there were these advantages, that they hadn't done that. Do you think that's something to weigh in the balance in the appellant's favour?
Not really, no.
And then the last question is this, and we can keep open actually the master plan. It was also put to you that this was a scheme that had built development in all 4 directions surrounding it. Do you remember that?
Yes.
And you were taken on a trip round the compass rose.
Somewhat.
First of all, the east, the 1960s housing to the east.
Mm-hmm.
And then to the south, it was put to you were the schools.
Yes.
But immediately to the south, what is there? What part of the school is it that's immediately to the south?
Playing field.
Yeah. And then what's next to the school playing field if one goes one field to the west, to the left?
You've got a wooded area.
Yeah. Is that surrounding by built development to the south to
No,
you?
it clearly shields it.
Okay. Then in the north, we had the brutalist watchtower or water tower. Stalinist brutalist.
Beauty is in the eye of the beholder.
Yeah. Is the northern part of the appeal site really being surrounded by brutalist Stalinist development?
To be fair, it wasn't suggested it was surrounded. It was suggested that there was there was architecture either in Stalinist water tower. I wasn't saying.
And then lastly, to the west, that was a reference. I think your eye was being drawn to what we know is Brookfield Farm,
Yes.
although I don't think it's the Brookfield Farm of Archer's fame. For that, we would have to go to God's own county.
Yeah.
But so far as built development is concerned, does Brookfield Farm strike you as being built development in a green wedge?
Clearly not when you look at this.
All right. Thank you very much, Councillor Holmes. That's all I have for you. Just hang on there in case the inspector's got anything.
I won't move.
Covered everything else.
So I can move.
You can now move.
And I still under purdah?
No.
Thank
No.
you.
Yes, thank you. Got my microphone on. Are there any housekeeping matters before we move on?
Yes, we've just put our heads together and we would ask you jointly, please, for a 10 o'clock start tomorrow.
Yep.
If
I was
that's
going to
all right.
suggest that. Yeah.
Inquiries were put in hand at lunchtime about the bus service as exists now and what plans there might or might not be for the future. And again, I'm gathering information from my side, feeding it through. We're going to try and produce a joint position to you so that you've got the agreed position. But I'm not sure there's anything else on your shopping list at the moment.
There was just confirmation of term dates, but that's
yes.
by the end of the inquiry.
Yeah, we'll get that as well.
Okay. Thank you then. We'll reconvene at 10 a.m. tomorrow morning. Thank you, everyone.